Good morning, everybody. Happy Friday Eve. Welcome to the Courtroom Files Live. Good to have you here. Let's start our day in Michigan, Judge Middleton, and stories about a bridge, no doubt.
May be available for some consultation. He's not here to actually represent you. We're going to start here in a minute. We are on the record. We are on the live feed. I'm asking everybody to take off their hat. If they have one, take your gum out if you have that. And as soon as I get the list of who's here, we can start. So are there still people out in the hall?
Yes.
Why don't you bring them all in? All right, for some of you, it's very early in the morning. For us, it's early enough. Judge McManus, who started our court more than 50 years ago, was an early morning guy. So we start at 8:15, and we get a lot done before 9 o'clock. I get here about 7:15, but we open the doors at 7:30. And it does make for early morning for people that are here, but sometimes we can get things addressed and get them back to work. All right, well, I don't know where my list is, but let's find out who's here. Is Samantha Hoff here? No. Here's my list. Better than asking who is there. Everybody, if you have a seat over on this side this morning, everybody walks in and turns to the right. We do have a couple of cases that appear would need an interpreter, but I don't see any of those defendants here. What?
You said you don't have to list.
This list.
Oh, that's
I got my cheat sheet.
how you never.
We also have one gentleman that has medical issues, and he's here by Zoom. I'll bring him in. We have a lot of people that are supposed to be here but aren't. But we ain't too proud to beg, so we'll just get started. All right, good morning, everybody. You're here for an arraignment. The arraignment is the process where the judge tells you what you're charged with and asks you how you wish to plead to the charge. When I call your name, I want you to come right up here to the podium, and then we will discuss your case. We'll start with Daniel Taylor. First person to check in. This is file number 2534. ST, that stands for statute traffic. There's some other numbers. Oh, Laura, I'm out of register of actions. I knew that late yesterday and I forgot to tell you. Mr. Taylor, you're charged with operating without a valid operator's license. That's a very common charge, sometimes called no ops. It's a misdemeanor punishable by up to 90 days in jail and a fine of up to $100. Carries 2 points. You were supposed to be here on December 11th, and you didn't come. You were supposed to be here on January 8th. You came the next day, and they reset the matter for today. Then you were supposed to be here on the 22nd. That's the day the pipes broke and the courthouse flooded. So they reset it for today. You're also charged with no proof of insurance, which is very common, and no proof of registration. I call these driving while poor. So let's take a look. Thank you. That ought to get me through. All right, Mr. Taylor, you got a ticket. on December 6th in the city of Three Rivers at 9 o'clock at night for reasons I don't understand. It was a deputy sheriff. It was in the city of Three Rivers, but it's written under state statute. Driving without a license, as I said, is a misdemeanor. It's punishable by up to a year in jail, up to 90 days in jail and a fine of up to $100, 2 points. No proof of insurance is a civil infraction. That carries a fine of $150. And no proof of registration is also a civil infraction. And that carries a $105 fine. Let's see why you don't have a license. You have a previous conviction in 2023 for driving without a license. You have another one in 2016. So you haven't had a license for quite some time. I guess, Mr. Gibson, what I would propose here is perhaps we'll see if we can get a prosecutor to speak to him at a pretrial conference. Mr. Taylor, you live in Three Rivers?
I do.
How'd you get here today?
A friend brought me
All right, where are they?
over to the coffee shop across the street.
All right, let's make sure you didn't drive here. All right, we'll see, May, if we can get the prosecutor to talk to you. Have you done anything to get your insurance or registration squared away?
I have the registration with me. The car wasn't my car,
Okay.
so I didn't realize, I couldn't find the papers. The car is insured because just got the tags. The tags were due in
All right,
the first
so
of
it
January.
wasn't your car.
Pardon?
It was not your car, but it's now registered and plated.
Yes, it was at that time also. And the new tags were just put on, or the new gate tag was just put on December 1st. And in Indiana, it's registered in Indiana. Indiana, you've got to have insurance before you get your tags.
All right, you have a seat for a minute. We'll see if we can get somebody to talk to you. May take a little bit, but I'll save you another trip over here. We're gonna make sure that you didn't actually drive here. Okay. We're moving at a snail's pace here, but sometimes that's how it goes. Mr. Rouse, would you join me, please?
Okay,
Appointments are done live. But this defendant has some significant medical problems. And I allowed him to come in by Zoom because he'd had difficulty getting here. You need to turn your camera back on.
I don't know how to do that, Your Honor.
Well, it was on when I saw you the first time.
I know, and my phone's been sitting on the couch, and now I don't have the video.
All right, well, let's talk about this. Are you Scott Harry Rouse? Sir? Now you muted your microphone, so we're even worse off. We're blind and deaf.
Okay, how's that?
Better. All right, are you Scott Harry Rouse?
Yes, sir.
Mr. Rouse, you got a ticket in Three Rivers under
Yes.
ordinance. I don't know why they set this for Thursday because they aren't here today, but you got charged with driving suspended. That's our most common offense.
Well, my ticket says revoked.
Well, you are revoked. You have multiple drunk driving convictions, which cause your license to be revoked. But this is the same statute. It's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Carries 2 points on your driving record, and it requires that your license be suspended. They say this happened on January 15th.
Yes.
How do you plead to that charge?
I plead guilty to it with an explanation.
All right.
When I got
Did
sentenced,
anybody promise? you anything to get you to plead guilty to this?
No, but I mean, I don't have a license, but I was unaware of it at that time. I went to court to be sentenced for the impaired, and that was in 2024. I went through the sentencing, which was 3 months restricted, and paid all my fines, and I thought it was behind me. I mean, when I got pulled over on the 15th, I was going to appointment with Pivotal that I have frequently, and then I was going to go to the pharmacy. And
Yeah, you were near. How come you can get to Three Rivers for your pivotal appointments, but you can't get to court?
because I could drive, that's thought.
Okay, all right, you thought you could drive. Yes,
Yes.
they revoked your license. When you
I-
get 2 drinking driving convictions within 7 years, they revoke your license. You got one in July of 2024, and you had another one in 2021. So they didn't tell you, but that would cause your license to be revoked. So at the time you got this ticket, which was January 15th, you were revoked. Or I guess I understand you can't get here because you're on oxygen and you no longer can drive and you live in another county. All right. Did anyone promise you anything to get you to plead to this charge?
No, but
All right, well,
No.
just a minute.
if I'm revoked,
This,
I didn't know.
go ahead. You're revoked. They've taken your driver's license for at least 5 years. For all of you, if you get 2 drunk driving convictions within 7 years, your license is revoked. Unless you do sobriety court, there's a way to get your license with an interlock. All right, I'm going to tell you some things. I'm going to tell everybody in the courtroom. Do you understand that by pleading to this charge, you're giving up your right to have a trial in front of a judge or jury? That will not be a trial. Do you understand that?
Yes.
If you had a trial, you'd have the right to be represented by an attorney. Mr. Gibson, the public defender, is here, but you could also have an attorney appointed to represent you if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court. Excuse me. So they could be questioned under oath. And you would have the right to take the witness stand yourself and testify, but you don't have to because you have a right not to testify. If you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. So you were going to an appointment at Pivotal on Millard Street, and you were then going to go to Walgreens?
No, friends.
Fred's, all right. And you live in Cassopolis?
Yes.
You now understand you can't drive anymore?
Yes.
All right, I'm going to give you a $100 fine, a $75 crime victims' rights fee, and a $50 state minimum fee. That's $225.
Okay.
Can you pay that within 30 days?
Yes.
All right, I'll give you a little more time. I'll give you till the end of March. That's due by 3/29/26. Is your address still South Street in Cassopolis?
Yes.
Does your phone number still end in 0319?
9498. It's 718-949.
But we have your correct address.
Yep.
All right, let me repeat. You just pled guilty to driving revoked or driving suspended on January 15th. You indicated nobody threatened you or promised you to get you to plead to this charge. I allowed you to appear by Zoom because you live in another county and you're presently on oxygen. I could see you when you logged in earlier. You had your oxygen equipment hooked up and you lost your license. So normally everybody else is here live, but you had a special dispensation. You owe me $225 by the 29th of March. Do you understand?
Yes.
I will send you notice. All right, Mr. Rouse, this matter's completed. Don't drive anymore. Sorry about that.
I have
All right.
I have a form here from Secretary of State on how to request a hearing to see if
Yes,
I can
you can
just get it. So I can just get
Ask
it.
for a hardship license, but unless they do that, in our county, we probably would have looked at you for sobriety court placement, but I'm not sure what they did in Cass. Anyway, you're good to go.
I do thank you, Your Honor.
Thank you.
Good morning once again, everybody. Happy Friday Eve. Welcome to TCF Live. Great to have you all here today. Courts are starting to get their days rolling, especially up in Michigan, but we'll ride with Judge Middleton for just a little while longer.
Stand up for the whole morning. The next person to check in is Raina Moyer. Would you come forward, please? Why don't you give her a hand there, Deputy, and let her sit at the plaintiff's table. Are you Raina Michelle Moyer?
Yes, I am.
This is file 252615SM. And 2614SM. And you got a ticket. Ms. Lemmerhart, nice of you to join us. Well, let's talk about this case first. We got about 9 of these today between arraignments and pretrials of people driving with no insurance. Often is combined with driving while suspended and having an improper, well, you're also charged with driving without due care and caution. Let's take a look at your ticket. They say this happened on 4:38 p.m. on M60 and Corral Road by the big curve. That you were driving while suspended, driving without any insurance, and driving without due care or caution. Can't tell whether there was an accident or something.
Sir, I had a seizure. I was about a block away from my house
Okay.
and I hit 2 trees doing, I had my cruise set at 60 and I took on 2 trees and I was hospitalized with a broken chest plate and foot.
All right.
I think your list, sir.
What?
Your list. You have it.
Oh, yeah.
Thank you.
All right.
But
Well-
that's what caused the accident. It was a focal seizure, which I am epileptic. I've been seizure free for 5 years and it came out of nowhere.
I'm sorry to hear that. You weren't supposed to be driving because your license is suspended and you didn't have any insurance.
I can plead guilty to the suspended, but I did have insurance and we're still trying to get it. It totaled out my whole vehicle.
Well, it's a big deal. And I say this a lot. When you're driving without insurance, if you're in an accident with somebody else, their insurance company is going to sue you. What kind of car were you in?
A Chevy Traverse 2017.
So that's a valuable car. If you don't have insurance, they're not gonna pay anything.
Well, they did and put us in a different vehicle.
All right, so you do have insurance?
Yes, I'm trying to get it. That's why I'm not guilty on the insurance part.
All right, well, what we'll do is we'll set this for a pretrial. 2526. The vehicle was totaled?
Yes,
How long were you in the hospital?
6 days. They took me to Three Rivers and then transported me to Borges. And I've been in and out of doctor's offices and appointments for the last 6, 7 weeks.
But has insurance. Let's talk about that. The charge of no insurance is not under the motor vehicle code, it's under the insurance code. It's punishable by up to a year in jail and a fine of up to $500. Fine is not less than $200 plus cost. So the minimum fine is $325. It also requires that you get fingerprinted.
I did that
Driving,
already.
all right, driving suspended is a misdemeanor, punishable by up to 93 days in jail and a fine of up to $500. We have lots of each of those today. Driving suspended carries 2 points. I'm going to ask everybody who's here on no insurance, do you have insurance now? And you do have insurance now, but you don't have the proof with you. So I'm going to set this out for a pretrial. You live in Leonidas?
Yes, sir, with my kid.
Okay, well, I'm glad you're still here to be here.
Me too.
I'm going to set for pretrial February 26th, 2026 at 8:30. Now, you also have a retail fraud charge
What?
that you got a ticket and you didn't answer it, maybe because you got in this accident.
I don't recall any ticket for that.
Let's take a look at it.
Yeah, because I'm curious to know myself.
You got charged in the city of Three Rivers on August 1st of 2025 with a retail fraud.
I don't recall that. I'm sorry, sir.
Well, let me find it. And then you never answered it. They didn't charge you with a misdemeanor. They charged you with a civil infraction. And when I prepare my cases each day with the help of my staff, we look and see whether anybody's got any open warrants or whether they owe us money for something else. And there are several people today that have other issues. And
Well, I'm willing to take care of that now that I know about it.
well, let me tell you what I do know about it. I thought I had a copy of it, but I couldn't find it. I asked for it, and I don't know what I did with it. It was at Walmart at 3:32 p.m. And they gave you a ticket. Deputy or Three Rivers Police Department, Gavin Etter, gave you a ticket.
I'm sorry, sir. I don't recall.
All right. Well, anyway, you didn't answer it.
I apologized.
They said we at the court sent you a letter and you didn't respond to that. So this case is kind of in limbo. All right. I'm going to give you a court notice. And she wants to address all right. And this is Thursday. The Three Rivers city attorneys are here on Tuesday. So maybe I should, well, we'll see. Let's address retail fraud in 25. 1622ON. Seems like that would be something you would remember if you got stopped for shoplifting and they gave you a citation. But I'm not exactly clear what the deal is. So I'm going to have the court officer take you out to the counter. We're going to set a pretrial for February 26th. So you'll come back in about 3 weeks. Bring your proof of insurance.
Yes, sir.
And you might want to bring your medical stuff too. And you may then want to address this retail fraud ticket. Retail fraud's a misdemeanor under state law, but Three Rivers and Sturgis have an ordinance where they can charge it as a civil infraction, which means it's punishable by a fine only. So they handed you a citation, it looks like, and then you never responded to it. So maybe they can give you a little more information. Anyway, you're going to get a formal notice and then you're going to talk about that retail fraud charge.
Yes, sir.
All right, you're good to go.
Once again, everybody, good morning. It's TCF Live. It's Friday Eve. It's great to have you here. I'm enjoying a great breakfast myself this morning of some fresh raspberries with some dark chocolate hummus from the fine people at Boar's Head. If you haven't ever tried that stuff, give it a try. It's like chocolate that's good for you. It's wonderful. I've said it 1,000 times. Stop stealing at Walmart. They have facial recognition and everything else now. You're not going to get away with it. Let's ride with Middleton for one or two more cases, and then we'll move on to somebody else.
I just got assigned to a Berrien County case.
It's a little bit of a drive.
Well, I got to go to Niles. Someone got charged with a crime, and the judges in Berrien County all disqualified themselves, and the state court assigned it to me.
Lucky you.
So I'll be going to Niles. I haven't been there in a long time. Anyway, you're charged with the crime of the day, which is no insurance and no operator's license and improper plates. Do you have insurance now?
Yes, sir. Insurance was obtained before the citation was even written. The night of the stop, Your Honor.
And you have plates too?
Yes, Your Honor.
Very good. And do you have a license?
Yes, sir. It was just expired. It wasn't suspended or anything, and it was also renewed before the traffic stop was even completed.
Very good. All right.
I
We're
also
gonna.
have documents of all that.
That's
as well.
great. You got all the proof with him. I let the prosecutor know that we had 8 of these. No, let me explain for everybody that's here for no proof of insurance. You heard me say it's a misdemeanor punishable by up to a year in jail and a fine of not less than $200. That's the misdemeanor. There's a lesser charge known as no proof of insurance. No proof of insurance is a civil infraction that carries a fine only of $150. So almost always, if the people bring in proof that they have insurance now, the prosecutor will dismiss the 1-year misdemeanor for a plea to the civil infraction. So you brought all the proof with you. You got it all. You got the plate squared away, you got your license squared away, and you got your insurance squared away.
Everything, Your Honor.
So I don't want to make you make another trip over here from Niles. So you also have a seat.
All right, I appreciate
And
it.
we'll see if we get the prosecutor to
All right, thanks, Your Honor.
I know Abigail or somebody is doing some other pretrials this morning, but would you let her know that we've got so far at least 2 instant pretrials for no proof of insurance? And maybe we can get the prosecutor to help us with these. Dustin Cole. Good morning, Mr. Cole.
One, sir.
I thought you weren't going to come see me for a while.
I was hoping not.
As we know, there's several Dustin Coles. You're Dustin Lee Cole.
I am.
Mr. Cole, you got charged with no valid operator's license. That's a misdemeanor punishable by up to 90 days in jail and a fine of up to $100. Carries 2 points. Let's see what we got here. Let's take a look at your driving record. I thought you got squared away.
Yeah, I was in sobriety court and I graduated. And then I
Yes.
wrecked my car and it wasn't worth having it towed to Wajack from Sturgis to fix it. So I sent the interlock back
Oh,
and then they
boy.
suspended my license for it.
As you know, we had the other Dustin Chevy Cole, and he died.
Yeah, I worked with his father.
He was a good kid. And so you lost your interlock, is that what
I
happened?
did.
And I tell people, I probably told you, it's when you're in sobriety court, you did a good job and you graduated. And but when you get out, it's so cumbersome and so hard to keep your interlock. So let's take a look and see what your deal is. What are you doing now?
For work,
Yeah.
bracing and jar, masonry.
What are you guys working on?
Right now, Friendship Village on Drake Road in Kalamazoo. It's a retirement home. Blocking brickwork.
Well, that's hard work. It pays pretty good, but you go from job to job. Let's take a look at your ticket. This was at 8 o'clock at night in Constantine. Written by a Constantine cop, but they didn't write an ordinance. It also had one headlight, like the wallflowers, and
Yeah, they gave me a warning for that because it was working after you pulled me over.
all right, well, they'll pull you over every time for a headlight. Just say, hey, your light's out. So let's take a look. Your life was not valid, restricted. Well, that was a long time ago. You graduated about 2017,
That was a long time ago.
10 years ago. How are you doing,
Doing good.
except for this?
Yes, sir.
All right, well, have a seat. There are some other things. The problem is, as you heard me say earlier, if you get 2 drinking drivings, you get revoked. Unless you're in sobriety court, where we can get you a license with an interlock. You had a restricted license and now it just shows as not valid. So are you going to try to get your license back?
I was in the process of doing that. I went to Secretary of State. They said I was a couple months shy of doing my test again. So I don't know if this is going to hurt.
When was that?
About a month and a half ago. Because I had to renew my ID. And they were confused because they said I got an ID. It takes away my license.
Yeah, I'm confused too.
So they said
One
I had a restricted
option,
license, but yeah.
one option is to set this out a couple months and see what you can do with SOS.
Yes, sir.
If you get dinged with this no ops, it's going to make at least a year before you can get your license back. If I bump this out to say March, have you come back and let us know what the status of your license is, perhaps the prosecutor can give you some consideration. There's a charge called allowing another to violate the motor vehicle code, which doesn't go on your driving record. And I don't have the authority to do that, but the prosecutor does. When they said a couple of months out, did they give you, I can't tell from looking at your driving record, when you're eligible. Yeah, you were burning the candle at both ends when you were young. Restricted from 17 through 17. Interlock violation.
They had violations for the windshield washer fluid and for the coffee.
Yeah, you did a good job. Are you still on Oxbow Drive?
I am.
How do you get back and forth to work? You got somebody down
My
here?
wife,
She drives you back and forth to?
Yeah. it's about a 38-minute drive.
All right. How about my suggestion? We adjourn this out a bit and see if you can get squared away with SOS.
Yes, sir.
2/6/26, 2/5/26. All right, let's take a leap here. We'll set it out for Thursday, April 9th. For a pretrial with the prosecutor. Bring proof of activity with SOS.
Yes, sir.
Now, don't drive any more between now and then. That'll just really unscramble everything.
All right.
Thursday, April 9. Bring SOS information. All right, let you get back to work. All right, maybe you can bring in something from Secretary of State, which would convince the prosecutor to reduce the charge. Put that on your refrigerator. That may be the only notice you're gonna get. And I'll see you on Thursday, April 9th, and we'll see what the deal is.
All right, thank you.
All right.
So Michael Groff put in the chat a little bit ago that he was out riding his new e-bike this morning around the neighborhood, blasting TCF as he was doing it. So first off, thank you, Michael, for the free advertisement to your neighborhood for the show. But it reminded me of when I was growing up. It was late 70s, early 80s, somewhere in there. There was this guy in our neighborhood who had a 10-speed bicycle, and he took two big, like, inside home floor speakers and mounted it to each side of the back wheel, put a car stereo on it, and then powered it all by a big car battery. And he would ride around the neighborhood just blasting music out of these big floor speakers mounted to his 10-speed. So I was thinking of that, and Michael, I think that would be a great mod for you to do on your new e-bike. So consider that. Okie dokie, let's change it up. A certain J. Cedric Simpson has started his day. Let's see what's going on.
Judge. No problem. Torso Peace, the first assistant public defender. Judge, we likewise do not believe that a conflict exists in these cases before this honorable court, but should a conflict arise, we will waive that conflict and allow this honorable court to please hear those cases.
The court also does not believe there's conflict either in the Michigan court rules. Other cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matter. Court does call the case of the people versus Romeo Smith.
Michael Gaddy, assistant public defender for Mr. Smith, Your Honor.
I don't see it there. Romeo Smith?
He's here.
Okay, thank you.
Yep.
All right, sir.
Sir.
State your name, please.
Muhammad Omar Ted Smith.
Thank you, sir. All right, what do we?
Your Honor, we received the competency update yesterday around 4:35, 4:40. I have reviewed it. I haven't had an opportunity to review it with Mr. Smith, given when we received it. I'd ask the court to adjourn. It did recommend a finding of competency, of competence. I believe he's got a couple other matters in circuit court, if I'm not mistaken. I'd ask the court.
What's the date of that?
I received it yesterday afternoon around 4:45. Let me check, Judge.
Was it dated January 5th?
Maybe so. Hold on.
The only reason I'm asking, that's the last report I have.
Okay.
Well, in any event, you're asking for an adjournment so that you can go through whatever the report.
That is correct, Your Honor. I'd ask for a week, and I can get in touch with Mr. Smith, and if he's found competent, we could probably do the PCC then too, if the court would wish to do that.
Well, I don't. What's 2 weeks now? 19. Competency hearing in this matter will be adjourned to February 19th.
Your Honor, the report is in. I think the expiration date of the 15 months on this is probably the 22nd.
The 22nd.
So
Of this month?
yes.
Great, because that's the day I'm setting.
Thank you, Judge.
9 a.m. Final continue.
Thanks, Judge.
Thank you, Mr. Smith. Court does call the case People versus Winona Harvey.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Ms. Harvey.
Try to trip you, Miss Gaines. Did it?
No, I think I was
tell
just
me.
a little clumsy.
No, you can tell me. I got people.
I appreciate that. I need people who've got people.
Okay. All right. There's Miss Harvey, I do believe. Miss Harvey, can you state your name, please?
Winona Harvey.
Thank you. All right. What are we doing?
Your Honor, we received a report with an update that that at this time Ms. Harvey is still found not competent. However, they do still believe that she is restorable. So we're just asking for another review date.
All right. Set a review date in this matter, 90.
May 7th.
May 7th, 2026, 9 a.m. Bond continued.
Thank you.
Thank you. Thank you, Ms. Harvey.
Thank you.
Court calls the case People versus Robert Watkins.
Let's see.
Joy Gaines, Senior Assistant Public Defender, representing Mr. Watkins.
Mr. Watkins, can you state your name, please, sir?
Watkins.
All right, thank you.
Your Honor, there should be a plea form from.
There is. I have a plea form that indicates, that indicates that the defendant will be pleading guilty to the charge of retail fraud in the second degree, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. And that's the court's full understanding of the.
That's correct.
Is that correct, Ms. Nance?
That's correct.
So Watkins, if you could please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name again for the record, please.
Robert Dwayne Watkins.
Thank you. You can put your hand down. Sir, it is this court's understanding that you're going to plead guilty to the charge of retail fraud, second degree. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes.
Still wish to put, I also have to apprise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 District Court. You understand that, sir?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You went through and had cause to be signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
You understand that you're waiving all of the rights that are contained on that form?
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you're guilty of this offense, sir?
Yes.
July 15, 2023, at the location of 5645 Jackson Road in Scioto Township, Washtenaw County, State of Michigan. What did you do at the Meijer that makes you think that you're guilty?
I walked in, grabbed some merchandise, and walked out without paying.
All right. The store was open to the public at the time?
Yes.
You didn't have anybody's permission to take that property, did you?
No.
Okay, and the property that you took was property that Meijer had offered for sale?
Yes.
And had you previously been convicted of retail fraud second degree in the 53rd District Court back on December 5th, 2013?
Yes.
Sir, I do have to advise you that if I accept your plea, if between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, nor would the court be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes.
Yeah. Counsel, are you aware of any other promises, threats, or other inducements which are part of this plea?
No, Your Honor.
And have I complied with this law?
Yes.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing will be
February 23rd at 9 a.m.
February 23rd, 2026, 9 a.m. before Judge Freshour. Bond will continue. Thank you.
Right.
Thank you, sir.
Thank you, Mr. Watkins.
Court calls the case. People versus Nikita Griffin. AG's in jail.
Good morning, Your
Good
Honor.
morning, Your Honor.
Special Assistant Attorney General Mitchell Wood for the people.
Thank you, sir.
Good morning, Your Honor. Assistant Blood Defender Davy Lieb on behalf of Mr. Griffin. Mr. Griffin, can you tell the court your name, sir?
Nikita Griffin.
Thank you, sir.
And Your Honor, we're going to be requesting a 1-week adjournment if we can get a plea offer on this.
A 1-week adjournment?
Ideally.
Well, ideally, are you going to have everything in 1 week, or
Your Honor, I'm just waiting on a plea offer.
you're waiting on a plea offer? That's likely not to happen in a week.
Perhaps two.
So you probably shouldn't ask me for that.
Judge, I can extend a plea offer. I can email. Which Assistant Public Defender are we dealing with here?
I don't know.
Davy Lebo.
All right. Spell your last name and I'll send you an email.
Lebow.
Yeah, it will be the standard offer. I mean, Mr. Griffin has a very large arrearage, $47,000. He's got to pay 25% of that to get a delayed sentence, and then he can pay it down by half to get an attempt, or pay it in full for a disorderly person. Kind of the standard offer is what I'm going to send you, Mr. Lebo.
Thank you.
And I have no problem with setting it over, Judge. We just need to make sure we don't need witnesses for next week.
Yeah, you don't need witnesses. Probable cause conference. I'm going to set this for the 19th, 2026, 9 a.m. Bond continue.
Thank you,
Thank you, Your
Judge.
Honor.
Thank you. Court calls case People versus McNally Gaines.
And then on behalf of people.
Mr. Gaines. That's it. Malik Gaines. Yes, we're here, Your Honor.
Take that. Take that off your head.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Gaines.
Your name, sir?
Gaines.
Thank you.
Your Honor, we're asking to continue to exam. Discovery is complete.
Okay, you're using is 26. No. 17. People have their witnesses available the 17th. Preliminary examination in person will be February 17th, 2026, 9 a.m. before Judge Moore. Bond will continue. Thank you. Court calls case of the People versus Joseph Jusba Odin. Yes. Ready to state their appearance?
I was waiting for prosecution.
Okay. Mr. AG, could you state your appearance, sir? Still here?
He was here.
Where is he? Oh, there he is.
I'm back.
All right.
Good morning, Your Honor. Special Assistant AG Mitchell Wood for the People.
All right.
Assistant Public Defender Chelsea Virgils with and on behalf of Joseph Jusba Odin. Can you state your name?
Joseph Jusba Odin. All right.
Your Honor, I haven't had a chance to talk to the Attorney General in this case. My understanding is that any offer would be contingent upon waiver of a preliminary examination. If that is the case, Mr. Jusba Odin would waive his preliminary examination on that case.
On both cases?
On the other case, we would like to ask to adjourn the possession case and.
All right. The possession case, and that's not an AG case, is it?
No, Your Honor.
No.
Okay. All right. So on that one, you're requesting an adjournment?
Yes, Your Honor.
I'll adjourn that probable cause conference to the 26th, February 26, 2026, 9 a.m. Bond on that matter will continue. And then on the other matter, sir, you're going to waive your right to a preliminary examination on the child support matter? Yes, sir. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them? Yes, sir. And you understand that you'll not have that hearing, you'll proceed to circuit court for further resolution? Yep. People also waive their right?
We do, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts. Counsel?
We acknowledge receipt of the information, waive its formal reading, and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea to both counts. Pretrial in this matter will be set for
February 18th at 1:30 with Judge Conlon.
February 18th, 2026, 1:30 before Judge Conlon.
Thank you, Judge. And Assistant Public Defender's last name, again, Judge, I'll send an email with an offer.
It's Virgils, Vergiels.
Thank you very much.
All righty, thank you.
Thank you, Judge.
Oh, is that it for the agent? Yes. All right. Court does call the case. People versus Hazel Jacobs.
Morning, Your Honor.
Thank you.
Morning, Your Honor. Sam Bernstein for Mr. Jacobs. Mr. Jacobs, can you please state your name?
Hazel Jacobs. Thank you.
Your Honor, we're asking for an adjournment to review the discovery.
That objection, probable cause conference will be adjourned to February 26, 2026, 9 a.m. Bound continue.
Take your
Court calls the case of the People versus Marcus Claiborne.
Sam Bernstein for Mr. Claiborne, Your Honor. Your name?
Marcus Claiborne. Thank you.
We're seeking an adjournment in this case, Your Honor. There's quite a bit of discovery. Tell the court there's also a co-defendant who's coming into the case today as well, so we're hoping to track with that. So we'll probably need maybe longer than the standard 2-week adjournment.
Who's the co-defendant?
Thurman Poole, Your Honor.
Mr. Cody Johnson is here.
All right. Then just remind me on that. I'll put this also out to the 26th. Try to match them up.
Thank you, Your Honor.
February 26, 2026, 9 a.m. Bond continued. Court calls the case of the People versus Benjamin Whitfield.
He should be on Zoom, Your Honor. We did a Zoom.
Benjamin Whitfield.
Bernstein for Mr. Whitfield, Your Honor. He should be here. I talked to him yesterday. I don't know what's going on. I'm sorry.
I don't either.
Yeah. Well, I know he's not here. I will get in touch with him very quick after, and we'll do the process to get back on track, Your Honor.
Okay.
No. I'm over here. I'm on here. I don't know how to switch it.
You don't know? Oh,
I'm trying to switch.
Didn't know how to flip. He didn't know how to flip your camera.
Yeah.
Yeah, if you had just turned the phone around, it would have worked.
I just turned it around, but I couldn't.
No, it's okay. You're good, man. Don't worry about it. All right.
It just came out with smartphones, Your Honor, so we're still figuring them out. Hoping for an adjournment to talk to Mr. Whitfield about the case.
All right, Mr. Whitfield, I'm going to adjourn your case. I'm glad you're here.
All right, thank you.
And I'm going to adjourn your case to February 26, 2026, 9 a.m. Bond continued. Thank you.
Thank
you.
Saved his proverbial bacon on that one. He was seconds away from a warrant. Morning once again, everybody. TCF Live. It's good to have you all here. There's probably some new faces out there this morning. If so, feel free to say hi in the chat. This is one of the best communities in LawTube. Very friendly people. So announce yourself. Say hi. Let's move along. We'll probably come back to Judge Simpson later, but let's go down to Florida. Wade Mercer, first appearances.
Good morning, ma'am. Ms. Michael, you're here for first appearance. You're accused of 2 charges. You're accused of 1 count of battery on a person 65 years of age or older, and 1 count of regular misdemeanor battery. The first one's a felony. The second one's a misdemeanor. Ms. Michael, there is probable cause for the 2 charges. Your husband's in the courtroom, ma'am, and the criminal history I've been provided shows no prior criminal history. Is that accurate, ma'am?
Yes, sir.
Okay. Ms. Michael, the question then becomes, do you have somewhere else you can live on a temporary basis other than the home where the alleged victims live?
Yes.
Where would that be?
In another county.
If you can't give me an address or a place you can live, then I can't consider a release option, ma'am. So where specifically would you live?
616 Gap Creek Drive, Fort Walton Beach.
Okay. Is that a family member or a friend?
It's a friend.
And you're confident they'll let you stay there, right?
Yes.
Are you employed?
I'm sorry.
You employed? Do you have a job?
No.
Okay. All right. Let me see if the state or defense have any additional information before I make a decision on bond or release status. Mr. McDaniel, anything else on behalf of Ms. Michael?
No, Your Honor.
Ms. Harris?
No, Your Honor.
Ms. Michael, I'm going to let you pick between a bond and a conditional release based upon the allegations and the criminal history. Ma'am, if you'd like to post the bond, it's $5,000 on the felony charge, $2,500 on the misdemeanor. The total bond is $7,500, but I'm going to offer you a conditional release because you have no prior criminal history. Some people prefer a bond because it has fewer rules to follow. Some people prefer a conditional release. I'm sure that Mr. McDaniels explained the difference to you. If you accept the conditional release, you'll have the standard conditions of release. At least on a temporary basis, you will have a condition of no contact with alleged victims. Sir, are you wanting any contact at all? Are you wanting telephone contact or no contact at all?
She needs to come home.
Okay. That may happen. Ms. Harris's office has got to look into this and have a chance to talk to you, and you're not the only alleged victim. That's the problem. There's allegations of child abuse. Now, they didn't charge her with child abuse, but there's evidence of child abuse allegedly pushing your 10 or 11-year-old child. Well, you told law enforcement it happened according to the complaint, and he told law enforcement it happened.
You just stepped in between us, that's all.
She didn't push it.
She did. She just got in his face and said, this isn't your business.
So back to my question.
Yes.
Do you want telephone? I'm not allowing personal contact at this point. Do you want telephone contact or not? Electronic contact? Miss Michael, do you want to be able to have electronic contact with your husband?
Yes.
It is husband, right? Okay.
We've been together 13 years.
So I'm just asking, are you married or not? Are you married or just, okay. So your name, sir?
Greg Doherty.
So you can have electronic contact. When I say electronic, I mean texting, emailing, telephone contact with Mr. Doherty, but no physical contact, no contact at all with the child at this point. Now that very well may change in the near future. We've got to give Ms. Harris's office time to talk with y'all and make a decision. But for right now, no contact at all with your son until we can get some things. That may happen this week. I don't know. But right now, no contact, and you can have telephone limited contact with Mr. Doherty, ma'am. And did you decide if you want to choose a conditional release or the bond, or do you have questions?
The release.
We'll grant you the conditional release. When you get here to the probation office, let me back up. What's going to happen, ma'am, is they're going to let you get dressed in your regular clothes. They're going to let you use the phone to contact friends or family for transportation purposes. Then they're going to bring you to the courthouse. When I say they, I mean the jail. The jail staff will bring you to the courthouse because that's where the probation and conditional release office is at. When you get here, you'll meet with Mr. Goodson or Mr. Ham. They will need an address of where you're going to be living. That's why I asked you that question earlier. And you'll give them an address where you're going to be living, and then you'll be free to leave. Someone can pick you up in roughly 30 to 45 minutes. You can be picked up at the courthouse, not at the jail, at the courthouse. The other thing we're going to do is I'm going to ask the jail to give you a notice for your court date, ma'am. Your court date will be March the 3rd at 8:30. That'll be your court date over in circuit court. And Miss Michael, do you have any questions?
Yes. What about my personal vehicle and my belongings?
Okay. Anything you need out of the home, such as clothing and things you might need for work. I know that you're unemployed right now, but things like that you can get. The way it works is when you leave the courthouse, you can contact law enforcement and they will instruct you on how to do that. The law enforcement agency that has jurisdiction where the home is located. So if it's in a municipality that has a police department, you have to contact that police department. If it's in the county, you have to contact the sheriff's department. And what they typically do is they'll meet you somewhere near there at an intersection or down the road somewhere. You will meet them, then they will accompany you to the home to get those personal items, and then you can't go back there at least until we get all this sorted out. So you can't go there at all without law enforcement accompanying you, and they're only going to do that one time. They're not going to let you get furniture, things like that. That's not their job. Their job's just to get what you need to go live somewhere else for a short period of time. And we'll see what happens. You may be back in that home the next several days. I don't know, but the state attorney's office has the right, they have the obligation to attempt to make sure that especially the child is not going to be in danger. Do you have any other questions, ma'am?
No.
Sir, do you have any questions?
You have her car right here. Give her the car.
Okay. So do you have another way to get home? If you leave the car here, you can't have contact with her, but you can leave the keys to the car if you have a way to get home, and she'll have a vehicle here.
Yeah, I got it.
Okay. So do you want to leave the keys with the probation office then? Okay. So he said he'll just leave the keys to your car with the probation office. That way you don't have to worry about transportation. So we'll have a vehicle here. Does that help?
That helps.
Okay. Sir, do you have any other questions? Mr. Goodson with the probation office, if you want to leave that car key with him, Mr. Goodson, if you don't mind, then she'll have that car. And then what needs to happen next is, I know you're already talking to Ms. Harris, spoke to Ms. Harris, but if Ms. Harris and them don't have a problem with her coming home and they feel like the child's not in any danger, they'll let me know that, then I'll consider modifying that condition. So this condition may be in effect for several days or weeks or for a very short period of time. I don't know. But for today, that's what we're doing. Any questions?
No.
All right. All right. Thank you, man. Wish you the best. Thank you, sir. Sure. And Ms. Harris, if y'all don't have an objection, if someone just shoot me an email, then we'll do an order modifying the condition of the release. Next case is Yana Bellamy. Miss Bellamy, good morning, ma'am. You're here in case 24-622 CT for the charge of driving while license suspended or revoked. We've been trying to get you here to get this case resolved for over a year now. We finally got you to deal with this case. Miss Bellamy, I'm going to appoint the public defender's office to represent you. You also have a hold from Houston County, Alabama. I'm going to ask you to listen to Mr. McDaniel, and we'll see where we go in this case. Mr. McDaniel.
Your Honor, I spoke to Ms. Bellamy. She's going to plead of no contest to charges listed. You understand she's going to be sentenced to 60 days in the county jail. She'll have 3 days jail credit. There'll be a $400 fine. She has signed a plea waiver form, waiving the right to a jury trial and call witnesses.
Thank you. Ms. Harris, is that agreeable with the state?
It is, Your Honor.
Thank you. Ms. Bellamy, did you hear that agreement?
Yes, sir.
Do you have any questions about that agreement, ma'am?
No, sir, Your Honor.
Ms. Bellamy, is that the plea you would like to enter to resolve this case?
Sir?
Is that the plea you would like to enter to resolve this case?
Oh, yes, sir. Yes, sir,
Ms.
Your
Bellamy,
Honor.
I'm going to accept your plea of no contest in case 24-622 CT to the charge of driving while license suspended or revoked knowingly. I'm going to adjudicate you guilty of that offense and sentence you to 60 days in the Jackson County Jail, credit for 3 days, court costs and fines of $400. Ms. Bellamy, you also, Mr. McDaniel's already spoken to you about the hold from Houston County, Alabama. Mr. McDaniel, I know a lot of times we'll deal with this when this sentence is over, but your text said you'd like to go ahead and deal with this today. Is that right?
Yes, Your Honor, and she just signed it in front of you, and we're just going to go ahead and waive the right to go to Alabama. So as soon as she gets done with this sentence here or close to it, jail can go ahead and ship her to Dothan.
Thank you. So, Ms. Bellamy, they have 30 days to pick you up, but that 30 days does not begin until our jail notifies them that you've signed the waiver. So usually when you get down below a week and remaining in your sentence, our jail will notify them to come pick you up. That 30 days will start. So Corporal Officer Whitakerson, if y'all would just keep track of that, and if she's still here 15 days after y'all notify them, please bring her back to first appearance, and we can see what's going on with the transport. But man, when you get down below a week, they'll go ahead and notify Houston County to come pick you up, and you can deal with that charge up there. Miss Bellamy, do you have any questions?
Yes, sir. What if I go ahead and pay the court fines?
You talking about here or there?
You said a $400 fine.
Yeah, that will, if you pay the court costs and fines in Jackson County, I don't know if it'll shorten the sentence or not, because you've got to work them off if you don't pay them. Frankly, I don't know. The jail can tell you whether or not that'll shorten your sentence. It may knock a couple of days off of it or not, because you've got to do community service if you don't pay them. It will not make a substantial difference in your sentence. I can tell you that. Any other questions?
No, sir, Your Honor.
All right, ma'am. Have a good day. Yes, ma'am. And then we've got John Hurst.
Here. Before that,
Mr. Hurst, good morning. Mr. Hurst, you're here for first appearance. Sir, you've been accused of 1 count of battery and 1 count of aggravated assault. Mr. Hurst, there is probable cause for the charges. I've also looked at your criminal history. I think you're entitled to a bond as far as I can tell, Mr. Hurst. But let me see if the attorneys have any additional information before I set that bond. Mr. McDaniel, anything?
Your Honor, he's been, I think, had a job for, I think about a year or so there doing spraying, out of Cottonwood. And, I don't know if the court can, I don't think he has a long history. He does have somewhere else he can live if the court is inclined to give him a conditional release.
Ms. Harris?
We would just ask for a bond, Your Honor.
Yeah, given the fact that he had a battery charge on the same person in 24 that was dismissed by the state at the alleged victim's request, I'm not inclined to give him a conditional release. It's a second arrest on the same person. Your bond is $5,000 on the felony charge, Mr. Hurst, $2,500 on the misdemeanor charge. Your total bond is $7,500. Cash or surety. You've got a condition, no contact with the alleged victim. Mr. Hurst, in the event she wants contact, I still wouldn't allow it based upon the prior history between you two. So there's no contact's not going to be allowed by me. Mr. Hurst, you've got the right to use the phone in a few minutes, sir, and try to post the bond. The jail's going to give you a notice for your next court date, which will be March the 3rd at 8:30, and you'll get to use the phone in a few minutes. Mr. Hurst, do you have any questions?
No, sir, Your Honor.
All right, sir. I wish you the best.
Yes, sir.
That traffic court today. Mr. McDaniel, that's everything I had on my list. Anything else from the public?
All right, that brings that to a close. I need to step out of the studio for a few minutes. In the meantime, I'm going to put you back with Judge Simpson, and I'll be back in just a little bit.
Will be set February 17th, 2026, 9 a.m. before Judge Washington.
Thank you, Your Honor.
Bond will continue. Thank you. Court calls the cases of the people versus Darius John.
No one understands.
Did I finish the name? Darius Johnson.
Brian Bowling on behalf of Mr. Johnson in case ending in 1734, Your Honor.
Yes, Your Honor. Brandon Bird on behalf of Darius Johnson and in the case ending in 5312. Mr. Johnson, state your full name for the record.
Darius Johnson.
Judge, we're asking that, my matter and speak for Mr. Bird, his matter gets set for preliminary examination. I believe discovery to be completed in my case.
Correct, Your Honor. Both matters set for exam, please.
You understand we have a violation?
We do understand it's a violation. At first we thought it was a progress report, not technically a violation, Your Honor.
Because it said progress report at the top of a violation. It says violation.
But Your Honor, respectfully, it is a lot going on with my client. He had a medical marijuana card.
Does he have one?
He doesn't. He doesn't have.
I just gotta renew it. So you don't have one?
Expired. So I technically don't have one.
He doesn't have a medical marijuana. He doesn't have a medical marijuana card.
That's either you do or don't.
I don't.
You don't. Okay.
It expired in 2023. But my client does suffer from PTSD, Your Honor. He went to prison at a young age, at 18 years old. He did 5 years in prison. Self-medicating. It's self-medicating off of that right now. He is taking care of his little brother. His little brother is his dependent that depends on him. Has one child. He has built a successful life for himself with a successful clothing line, but still times is difficult, Your Honor. Taking care of his little brother, taking care of his 3-month son. Went out of town to see his son because he needed to.
Can I chime in? I just got there's no excuse for me not having it. I just got it. Like, you just give me the opportunity to get it. I can have it like tomorrow.
You can have what?
Tomorrow. I can just go online and get it.
And he did come up here. He knew it was going to be a chance.
No, he was supposed to community corrections told him to discontinue use until he had that medical marijuana card was received and it was approved by the court. But you didn't do that.
No, I didn't.
And that was back in January that they told you that. And you still continued to use.
I did.
All discovery is complete.
In my case, yes, Judge.
In my case, as far as I know, yes, Your Honor.
People, other witnesses available to 17. Preliminary examination in this matter will be set February 17, 2026, 9 a.m. before Judge Moore. At this point, you can't follow instructions and have you out. Bonds revoked if any demand. This case is People versus Thurman Pool.
Your Honor, Raymond Cook.
This is what?
26.
26. Morning, Your Honor. Good morning. So, Mr. Johnson, where do you?
No PD assignment?
No, it's not a PD case.
Oh.
It's another bald guy. That's not in uniform. All right. Go ahead, sir.
Good morning, man. Please, this honorable court. Kareem Johnson, on behalf of Mr. Poole, standing my immediate right.
Chairman Poole, thank you. This is the co-defendant to another case that's coming along. We had adjourned the probable cause conference to the 26th. Is that going to work for you guys?
I'll make it work, y'all.
All right. Probable cause conference in this case will be adjourned to February 26, 2026, 9 a.m. Bond at this time will continue.
Thank you, John.
Thank you.
Y'all have a good day.
Do the same. Is that it for you?
Yes, sir.
Okay. Court calls the case, People versus Thomas Clemens.
Bird on behalf of Thomas Clemens. Mr. Clemens, can you please state your full name for the record?
Thomas Allen Clemens.
Thank you, sir. You're asking for an adjournment.
I'm correct, Your Honor.
Probable cause conference will be adjourned to February 26, 2026, 9 a.m. Bond continue.
Your Honor, respectfully, is there another date that we can do it?
What, you need another date? Or?
No.
You're good?
I'm good.
Okay.
Okay, we good.
All right. Court calls the case, People versus Ernest Gardner.
We're going to Sam Bernstein for Mr. Gardner.
Gardner.
Your Honor, we are asking for an adjournment to review the discovery, and I'm hoping to make a bond argument as well.
Man. I lost my screen. Seeking an adjournment on this one.
Please, Your Honor.
I will adjourn the matter to the 19th. Probable cause conference will be adjourned February 19th. 2026, 9 a.m. Esteban.
Judge, Mr. Gardner submits that he can be saved in the community if given a PR bond. He reports to me that he was doing really well before he was arrested. He was working for a program that enabled him to work in exchange for housing, and it was going well. He believes that he can get back in if he's released. He's unable to get back in. He does have a place to stay with his sister, who lives locally in Washtenaw County. He will seek other work. He is motivated to resolve this, Your Honor, and he promises to attend all court dates and follow through with all bond conditions.
Your Honor, we believe that where bond is currently set is appropriate. Most of the situation where, as I recall, we may have been staying at a hotel, and through the course of this, did threaten to kill or someone, right, to have them kill the officers who were involved and/or their families. We believe this gentleman is
He threatened to kill the officers in his family.
He has all the history of dangerous public.
Anything else?
No, I leave it at.
I'm going to deny the motion for bond reduction. Bond will remain. Thank you.
Yeah.
Case People versus Khalil Taylor. Jeff?
Last one, Your Honor.
This is your last one?
Last one.
Sad.
Yes, Your Honor. Brandon Bird on behalf of Khalil Taylor Jefferson. Mr. Taylor Jefferson, can you please state your full name for the record? Khalil Taylor Jefferson.
What are we doing?
Respectfully, we're gonna waive preliminary examination.
You're waiving your right to have a preliminary examination?
Yes.
You understand that that's a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination, never been waived. Defendants bound over to circuit court on a single count.
I'll wait for my reading, stand mute, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
April 1st at 1:30 with Judge Conlon.
April Fool's Day. April 1st, 2026, 1:30 before Judge Conlon.
Thank you. You, before have a great day, Your Honor.
You do the same, sir. Always a pleasure. Court calls the case, People versus Mark Carter.
Alan Zend on behalf of the people.
Portion of Fisher, Assistant Public Defender on behalf of Mr. Carter, who is approaching the podium. How you doing, sir? State your name for the record, please.
Mark Carter.
Mr. Carter would like this matter set for a preliminary examination, please, Judge.
Discovery is complete.
To my knowledge, Judge.
People have their witnesses available the 17th. Preliminary examination in person, February 17th, 2026, 9 a.m. Before Judge Washington.
Thank you very much, Judge.
Thank you. Bond continued.
Yep.
Court calls the case of versus Deshaun Jones.
Edward Lucas on behalf of Deshaun Jones.
Needs to buy a vowel.
Deshaun Jones.
Thank you.
I'm asking for a little bit more time to negotiate with the prosecutor.
So, probable cause conference will be adjourned to February 26th, 2026, 9 a.m. Bond continued.
Thank you.
All right. Thank you, sir. Oh. I'm just saying. Making a wheel fortune. Court calls the case, People versus Mario Crawford.
People.
Assistant Public Defender Virgil Smith and on behalf of Mario Crawford.
Mario Crawford, Your Honor. Thank you.
We're asking to adjourn for a session.
This is the only thing he's held on.
Your Honor,
That he was actually just recently charged with another RNO, has not yet been released on that case. It looks like that was entered on the report.
Oh, okay. Why don't I do this? Normally I put it out 2 weeks, but why don't I put it out to 26, see if we get him arraigned and get these cases at the same time.
yes, Your Honor, that's
All right.
fine.
So I'll put it out to February 26, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Thank you, sir. All right.
It's a beautiful day here at TCF Live. I hope you're all enjoying yourselves. Thanks for taking time to join us today. Very much appreciated. A couple things. First of all, a little while ago, Barbara dropped a link in the chat for TCF Bingo. And we don't call this out a lot here anymore, but especially if you're new here, yeah, the Courtroom Files has a bingo game. You can find it at tcfbingo.com, and the gist is, as you're watching, you play along on screen, and you fill out your bingo card based on what you see and hear in the court. It's fun, it's interactive, it's a good way to pass the time as you're enjoying court, so give that a look if you haven't already, tcfbingo.com. Tonight, Sidebar, 8 p.m. Eastern, 5 p.m. Pacific. Michael Groff will be hosting tonight. He has the reins, so be sure to check that out. And as well, just a programming note, 4th hour today, I'm just going to continue with court. I have a crew here at the bunker, just like I did the other day, working on some stuff, and I need to be a little more available for that, which precludes me from getting into long discussions and commentary about things. So 4th hour today, we're just going to do court. Let's head to Texas. Change it up. Say good morning to Judge Stevens.
Asking set.
Who has muted himself. Let me bump him forward a little. All right, let's not go to Judge Stevens because he's all muted and stuff. I hate when he does that. Let's do Judge McNally instead. We'll say good morning to him.
Your name? You work?
Yes, sir.
Why are you playing around with these?
You mean the TV, sir?
Yeah. You got one from 2024 you still haven't paid. You got two others from 2025 you haven't paid. What are you doing? Where do you work at?
Already at the airport.
What do you do there?
I clean.
How much do you make?
Probably around 600 a week.
When do you intend to pay these, or are you gonna make me lock you up? I don't want to do that.
No, I actually didn't pay.
Like when?
It's totally possible. So.
I don't know what that means. You probably said that to me back in 2024.
No, I wasn't able to come in 2024. When I came to pay the ticket,
Weren't able to come. What's that?
Because when I initially got the ticket, I came to pay, and I had just moved into my apartment, so I had gave them the wrong day. Because the lady told me not to pay because I would get 2 points automatic. So
you just didn't pay and you didn't come up and show up, right?
Hmm.
Okay. Mr. Ned, how old are you?
I'm 23.
Did you graduate?
You gotta take that phone out.
Phone's gotta go out of the building.
That's all over the door.
Phone's gotta go out of the building. Come on. Are you married? Kids? No?
I'm taking care of my sisters.
Do you have any money to pay today?
I have around $500.
You gotta stop doing this. Okay? All you gotta do is go and talk to a judge. I don't care if it's here, wherever. You go and talk. Hey, I'm having a hard time, but you can't ignore courts like this. Heather, how much does he owe on this 25T647119118? I see, it's 198. Here's what I'm gonna do for you, okay? Good morning, Mr. Cayley. Hey, did you talk to my judicial clerk?
Yeah, Heather's.
Yeah, okay. On 25W8400071, Heather, I'm gonna have him, he owes 288 plus his clearance fee. I'm gonna reduce the balance to 210 plus the clearance fee, so he has to pay 255. He'll walk out with the clearance on that one. On 24F 242804, he owes 225. He's gonna pay 175. I'll waive the balance. On 25T 647118, he's going to pay 160. He owes 198. I'll waive the balance. So those tickets there would amount to 430, 590. You don't have that much though, right?
I have,
It's fine if you don't.
I really don't. Yeah.
Okay, so I'm gonna give you until you pay this one by February the 20th. And I'm talking about the last one. You said you have about 500, so you're gonna go down and pay 430. And you're gonna come back on 25T 647118. That's the speeding. I'm reducing that to 160. If you want to apply something toward it today, you can. If you don't, that's fine. Next time you have a problem, come talk to me, okay? Will you do that, please?
Okay.
All right, good luck.
Oh, God, thank you, sir. My mom is in the hospital. She's been in the hospital for 2 months, so I really appreciate you today. And
Oh, geez, I'm sorry about
no,
that.
you're fine. I just wanted to say thank you.
Is she gonna be okay?
We don't know. She had a aneurysm and a stroke, and she wasn't as multiple aneurysm. A couple strokes and a couple seizures.
I don't want you to not be able to eat. Can you do this without?
I'm just I can do it. Me and my aunt have to take care of my sisters and paying her rent, my rent. So
I'll tell you what. You have $500, right? Yes?
Yes, please.
You pay 70 on file 118. We'll call it a day. I'll waive the balance.
Thank you,
It doesn't work out bad when you come and talk to us, okay? Good luck, and good luck to your mom,
Thank you, sir.
okay? Best of luck to you. Tori Elizabeth.
Very nice of Judge McNally. We like Judge Dad here. You know, he comes across as tough and gruff, but ultimately he really tries to work with people. So you got to like that. I just took a look. Episode 225 today of TCF Live. Time flies. It doesn't feel like we've done this 224 previous times, but we have. And thank you all so much for all your support. Let's head down to Texas. 9 to 11% more Judge Boyd, as we always promise here.
For me, because I get seasick when the screen
Yes,
is.
ma'am. See,
All right,
sorry.
is that called seasickness if somebody?
Motion sickness.
There we go. Thank you. Motion
I
sickness.
get it too.
I wouldn't be around water because I can't swim. All right. Court, except with
Rachel tried. Rachel tried.
Your daughter did try to teach me to swim. It was a failure. And you know what? That's because
Valiant attempt.
she tried, Virginia tried, and Hannah tried. All right. That's a story. That brings a smile to my face, remembering our trips together. All right. The court is calling 2023 CR 5888 State versus Anijah Gifford. Could I have parties announced for the record for the state?
Brandon Brandon for the state. Robert Maurer for defendant.
And are you Anijah Gifford?
Yes, ma'am.
And so the record is clear. I can be fair. I never went on a trip with Mr. Maurer. I went on a trip with his sister, and it was for international CLEs that I was the director of. So does anyone have any issues with my continuing?
I certainly don't.
Okay. All right. Thank you. All right. Ms. Gifford, you entered a plea.
Yes, ma'am.
And it's the court's understanding that the state has amended the plea bargaining agreement. Did you have a chance to review that amendment with your attorney, and did you understand it?
Yes, ma'am. Oh, wait.
Yes, we went over that together or not?
Yes, sorry.
So is there any objection to proceeding with your plea bargain agreement under the amended plea?
Not from
No, ma'am.
All right. And the court will note for the record that the original paperwork for the plea bargain agreement was signed. The amended plea bargain agreement, where the state is silent, was not signed by the defendant. Ms. Gifford, could you raise your hand for me, please?
Yes, ma'am.
Solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right. You can lower your hand, state your name for the record.
Anijah Gifford.
All right. Do you have any objections to your attorney writing your name with regards to the waiver of appeal portion of the document?
No, ma'am.
And stated defense, it's the court's understanding that Ms. Gifford paid the entirety of the restitution. Is that correct?
That's our understanding, Judge.
That is correct, Judge, and I tendered a copy of that to the state.
All right. This is what the court will do. The court will sentence you to 6 years deferred adjudication. Oh, I'm so sorry. Odyssey is down. Just give me one moment. Yes. But it's going to be a great day. Mm-hmm.
The number of times I've heard the phrase Odyssey is down in the last year. We can't complain about it.
No.
Yep. Other counties are like, why did y'all use Odyssey? You didn't know how bad it was?
Mhm.
Yes.
So now it's taking.
Got a kickback.
All right. It is preparing the session. All right. So, oh, I'm so sorry. State, you may be excused.
Oh, thank you.
Thank you.
I was gonna say.
No, I appreciate it. All right. Ms. Abrams, are you ready?
Ready.
And Cindy, are you ready?
Yes.
Okay. It says getting your case.
I'm gonna bill the county. Well, that's okay. They won't pay it anyway. The MAC will lose the voucher. Auditor will forget to sign it. Bethke's running for DA though.
Okay, so it's going to be 8 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Which county are you in?
I'm located in Augusta, Georgia, Richmond County, I believe, or Columbia County.
All right, I'm just going to say transfer to Augusta County. I'm sorry,
Okay.
to Augusta, Georgia.
Okay.
And you need to let probation know which county that is.
Yes, ma'am.
Ms. Abrams, if possible, field visits one time per month for 2 months. The court will find that restitution has been paid in full. There is to be 200 hours of community service restitution. Do you have any children?
No, ma'am, just the one on the way, and he's due next month.
All right. I'm going to order parenting classes. Once those are completed, the community service hours are deemed satisfied.
Yes, ma'am.
There's $1,000 fine, and that will be probated.
Okay.
Probation, is there anything else?
Judge, I heard you correctly saying 6 years deferred adjudication, correct?
Yes. Oh, I'm so sorry. Yes, 6 years.
And that was 200 community service hours?
Yes.
Nothing else, right?
Is there anything else you need from the court in order to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendants' Right to Appeal with your attorney? Did you understand it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal.
Yes,
With
ma'am.
regards to the trial court certification, the court will note for the record that the defendant was unable to sign the trial court certification of defendant's rights to appeal. All right, we can go off the record. And this court communication is key. You're going to be supervised by the probation office in Augusta, Georgia. You will still need to follow their instructions and their rules. Do you understand?
Yes, ma'am.
if a motion to revoke is filed, what will end up happening is that you will have to come back to Bear County. Do you understand?
Yes, ma'am.
It's very important that you follow all of the instructions that are being given to you. Do you
Yes, ma'am.
understand? If there is an issue, let your probation officer know and Augusta know. If you feel they're not addressing it, you can call probation here, and you can always zoom in and take it up with me if you feel no one is addressing those issues.
Yes,
So,
ma'am.
excuse yet. I'm going to send you to a breakout room. Probation is going to go over conditions with you. Once she's finished with that, then you can just excuse yourself from this Zoom. Okay.
Yes, ma'am.
All right. Good luck. Thank you.
Yes, ma'am. Thank you.
Thank you, Judge.
Okie dokie, Judge Boyd, ladies and gentlemen. Let's stay in Texas, but I think Stevens is finally unmuted now.
Okay. All right. Set for trial. Let's go to trial and try to get this thing. How many cases?
Yeah, she's going to ask you this.
There's two cases, or are there two sets? Is this two individuals injured? Is that what this is?
Yeah, sure.
Okay. Curtis.
Present, Judge.
Joshua Curtis.
Yes, sir.
Whoa. 4 cases? 5. 1, 2, 3, 4. What?
Nina, I stepped out of the studio and missed it. Thank you for the $10 super chat. Appreciate it. She says congrats on episode 225. Thank you. Would not be possible with all of you. So thank everybody so much for your support. And Nina, thank you again for the $10.
That's going to put us in a little bit of a holding pattern.
Why? I was indicted out of the same matter?
I don't know that yet.
Well, if it's not,
I think it's the same material, but I don't know exactly that.
It
may be the child pornography charge and not the others, Judge.
I had 5 cases, correct?
Yes,
5.
Judge.
You know, I'm signed because it's over a year old, and now we got a roadblock, right? I don't like that, but what state say?
Well, Judge, my personal opinion is that it's not really a roadblock. It's just additional prosecution from a separate jurisdiction. These matters stand on their own.
Okay.
I'm not the attorney assigned to it, but looking at it, they need to be resolved independently of whatever's going on over there.
We got 7 resettings. We're putting it on the trial docket. That's what y'all want. But we're moving forward. Okay. And it'll be first degree felony on 24 CR 2459 first.
Before I commit the state to that, Judge, I want to make sure that that's not the same or similar matter that's being prosecuted in the feds. Again, looking at this, I would likely want to try, if I was picking, I would likely want to try the burglary of a habitation.
I understand the cases have been moved. The only thing I would ask with court, a little bit of grace from the state. If I come in here and say, you got indicted by the federal government yesterday, can I at least figure out on his behalf what's going on that before we...
It's not going to go to trial tomorrow.
Know that, Your Honor, but it is going to trial quickly.
It'll get on the trial docket quickly. But if you've got legitimate problems, I'm going to allow you to get some relief. I just need to get this thing going. But okay. I understand the states, but those, even if it's similar, they can carve out 2 convictions out of it.
Yes, sir.
2 jurisdictions can do this, can take care of their business. And I'm just looking at, that's the first degree felony.
Yes, sir.
The others are lesser. But what is the state? I generally yield to what the state wants to try first unless the court has some special reasons otherwise.
All the cases will go there, Judge. We'll research and determine which one we want to go on first, John.
We're going to set it for an announcement in 4 weeks or 5 weeks. Is that going to be good enough?
I hope so.
Okay. Fine. Are there any other terms of probation release that are important here since we're dealing with this type of matter that involves vulnerable?
You know, I don't know if you've entered some of your standard conditions that you like for these 4 cases that I'm looking at that look like they're involving computers or some other kind of devices. I know you'd have some conditions.
If there's some issues, let me know. Right now, we'll keep it status quo, set it for review in 4 weeks. Okay, thank you. Race Hawa, Tom?
He's president.
Great, Granny. Thank you for the $5 that you donated on the TCF Bingo site. I very much appreciate that as well. Thank you so much.
What happened?
No,
I'm right there for me.
no, you're not entered.
Oh, weird.
Oh, might have been a mistaken comment. We haven't entered it yet.
All right, well, what are we doing?
I have 4 weeks on this, please, Judge. The last time we were here, I told the court I was anticipating an indictment in Galveston County. It doesn't make this case any less important.
What happened? Oh, you still
It hasn't been indicted yet.
What did they? Have you any word from them about?
Yes.
They intend to move forward.
That is what I have been told by the prosecutor that I'm talking to in the DA's office in Galveston.
All right.
It's unrelated. It's separate.
Let's review it in 4 weeks. Okay. I have Michael McLeod.
No, we just did a separate indictment for the same offense, for a similar offense, same charge, excuse me.
Where's McLeod?
That was added yesterday.
Is he here? Michael McLeod? No answer in the courtroom. I'm going to ask the bailiff to call into the hall for Michael McLeod. Are you also working on?
He's covering
Christopher Clinton? Are you covering?
Yes.
Christopher Clinton?
Yes.
Not yet.
So.
Oh boy. On Michael McLeod in 24 CR 1976, there is no answer to the name called in the courtroom. No answer to the name called into the hall. Defendant has failed to appear as required. Bond amount?
$15,000.
His bond is revoked. Warrants shall be issued for his arrest. His bond is now doubled to $30,000, plus he must have a GPS device as a condition of bond. So we know where he is when he's not in court, when he's supposed to be. Christopher Clinton.
I may haven't done that yet.
On Christopher Clinton. Review.
This is that case that Mr. Gertz is trying to lift his requirements to register because of the offense out of Arkansas doesn't necessarily fit our statute here.
We're awaiting answer from Austin.
Just filed multiple lawsuits and all that. Just I think my memory is he got a ruling from one court that wasn't in his favor, and he's appealing that, Judge.
What are the parties asking me to do today?
I'm asking for another announcement.
Without Mr. Gertz here, I can't disagree with that, Judge.
It's my best shot.
What is the case decision that the state has?
My memory is that Mr. Gertz has made an announcement that.
No, what's the case decision that you said,
I've not
does not
seen.
help him, it helps the state?
He made the announcement in court that he lost the case that he had filed in Austin, and he thought it was right, so he was taking it up on appeal. That was the last thing that he announced in court, and I'm sure he's brought Mr. Kelly up on that, Judge.
You know what it is?
I don't, Judge.
And I do know that it was a lawsuit against DPS trying to lift the requirements. This individual
Department
to
of
have
Public
to register.
Safety versus Benuti or Bernouti.
I believe he
decided. Instead, the department cites an unpublished, never cited 2014 case from the 13th Court of Appeals. And this is petitioner's reply to DPS's reply regarding plea to the jurisdiction. So I wonder if it was that particular case. That's the only case I see that's mentioned in.
I know we
matter, and this is, here's a big case, that's a thick case on Bernouti, the Bernouti case. That must be the issue, whatever's in that.
Yes, sir.
That's what this is all about. So any prediction on what is going to happen that will make a difference in the direction this heads?
I think if the ruling is that he did not have to register in the first place.
Right. I'm thinking that, but we really don't have a grasp on when that decision might come down, right? Okay, so we just keep reviewing in 4 weeks.
Yes, sir.
Okay. Anything else? I think that takes care of everything. Anybody here who's supposed to be here? Didn't call your name.
All right, looks like he's wrapping up his day. Let's go back to Judge Boyd.
All right. Court is calling 2025 CR 012673 and 2025 CR 015638. State versus Charlie Marquez. Can I have parties announced?
Ready? State.
Warren Wolf for Mr. Marquez.
And are you Mr. Marquez? You entered into a plea in each of these cases. You entered a plea of no contest. According to the plea bargain agreement, punishment is to be assessed at a cap of 8 years in the prison. There's a $1,500 fine. State is opposed to your applications. They are running this concurrent with each case with a county court cause number 2024 CC 73799 and 2025 PF 09446. And taken in consideration will be 2025 CR 011814, 2025 CC 0046665, and 2025 CR 011499. And in one of the cases, there's an affirmative finding of family violence. There was a TAP evaluation and a PSI report that was completed. Have all parties had a chance to review the PSI report and TAP evaluation?
We have, Judge.
Yes.
Any objections to those documents, state or defense?
Not for the state judge.
No objection, but there is a correction about Mr. Marquez's recognition of his issues with alcohol. And he is willing to take treatment. In fact, he is we'll explain that later. He's with CPS program now, and there is alcohol treatment being provided for him, and he's participating there.
All right. State, you're opposed. Do you have any witnesses?
No witnesses, Judge, just argument.
Defense, do you have any witnesses?
Mr. Marquez, bless you. And in addition to the documents that you have, and I've tendered these to opposing counsel, certificates of his participation in the Supporting Dads program, his taking drug tests that are negative, and his participation in the Family Violence Prevention Services, where he's been attending.
All right. Any objections to the court reviewing those documents? All right, it's not listed here, but when did he start the violence prevention program?
2 months already.
Okay. And I just asked because I saw where he was on the 7th class. All right. And you want to call your client?
Yes.
Can you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Charlie Marquez.
All right, Mr. Marquez, I want you to know that you may see me reading documents. It's documents that are related to your case. It's the PSI TAP evaluation, but I'm still listening to you and I'm able to internalize everything that you're saying, okay? All right, defense, you may proceed.
Mr. Marquez, I know there's a lot of issues that you've had in the past, but that is not who you are today. Is that correct?
Oh, and I'm so sorry. Could y'all speak up a little bit so I can hear?
Where are you currently working?
Work at a restaurant called Twin Peaks full time.
And what do you do there?
I'm a head cook.
And how long have you been working there?
Over 9 years.
And you are currently living with another lady, not the lady that was involved in the case that's before the court, correct?
Yes.
And the name of the person that you're with now?
No.
Well, you're not under this, but you're working through that through CPS?
Yes, correct.
How long have you been going to CPS classes?
CPS, I've been going to CPS for over a year, CPS classes for almost a whole year as well.
And what sort of things are they talking to you about there?
Counseling classes, substance abuse, drinking, violence, big re-entry program.
What is the goal of those classes regarding you and your children?
To reunite the family.
And your daughter, right?
Yes.
Where is she currently staying?
They're staying with my mom.
Okay. With your mom, not their mother's mom. Correct. There was an issue with her. What was her name? Crystal. That she had some drug issues. Correct. So CPS thought it wiser that the children not be with either you or her, right?
Yes.
And they're with your mother. Do you get to see the children?
Yes, every week.
Is it supervised?
It's supervised 2 hours with my mom.
And has there been any issues in that regard?
No.
I know you said that you've been taking some substance abuse classes with CPS. I noticed also, we showed the judge some documents that you've been tested. Have there been any positive tests since you've been going through these programs?
I think over a year or so. Last year, maybe just one, and that was it.
And since then, you've been sober.
Yes.
And that is where you know you need to be.
Yes.
You know that is a major issue with your situation. All these cases that are before the court, whether they're being taken into consideration or the ones that the judge has to rule on and make a decision what happens to you going forward. Alcohol is a major issue that you need to confront. You understand that, correct? And you are doing that.
Yes.
And you're doing that successfully, correct?
Yes.
I showed you some of the programs that the court could place you under that have been indicated by probation. Are you willing to abide by any of the conditions that the judge may impose on you in order to keep you in the community and towards reuniting with your family and helping to provide for their financial support role?
Yes.
Okay. Is there anything else that you wanted to tell the judge?
Just I have a problem with alcohol.
Questions, Judge?
Yes.
Can I call the, Mr. Marquez, can I call you Charles?
Yes, that's fine.
Okay, all right, Charlie. Well, first thing, let's just be honest right now, because honesty is the best policy. If you're dishonest, we're gonna snip out right here, so just be upfront with my questions. All right, let's talk about, Crystal. How long were you in a relationship with her?
We've been married over 14 years.
Okay. Are you living with her right now?
Right now she's currently employed and out of the house. But with
But you're not under the same roof.
Yeah.
Just listen to his
All right,
question.
yes.
Okay. All right. Let me ask you, did you ever contact her?
We have we have to be in contact only for the visit for the kids.
For the kids? Okay. How many kids do y'all have together?
We have two.
Two? Okay. Boy, girl?
You got two boys.
Okay. How old are they?
One just turned 13, the other one is 10.
That's gonna be a ripe age for two boys, man. Right? Okay. Let me ask you, so when you're communicating with her, did you ever tell her about not talking to the DA's office?
I went to the evaluation last week and I told her she was supposed to call I forgot his name, Doug, to about a statement.
Okay, and is that the have you ever heard of something called an affidavit of non-prosecution?
No.
Okay. All right. Let's talk about, because we got a few cases, one of which is involving Crystal. So let's talk about the first one. Did you get deferred adjudication for an assault family violence?
For the first case, yes.
Okay. Was that with Crystal?
Yes, correct.
Okay. What about the second case, man?
It's also with her.
Okay. Let's talk about, so I was reading the PSI. You were saying in there that you had no alcohol problem, right?
Yeah, because yes, right.
Okay. But you also said that your alcohol use has increased over time?
After my brother passed away, it's been a year this coming week that he's been passed.
Have you tried to stop using alcohol?
Yes.
Okay. Have you been successful?
Somewhat, but I do notice that I do have a problem.
Okay. What do you mean by somewhat? Did you go for a little bit and then fall off the wagon?
Yeah, because like I said, it's been just a year now. My brother passed. It's been hard on our family.
Okay, I get it. Was your alcohol use a factor in that evading with the vehicle that you got back in July 26, 24?
No.
Were you intoxicated that night?
I made it home, got out, and they never, was it blood test me when I got into the Fair County.
Okay.
And I had alcohol in my system.
Did you stop for the police?
I had stopped the light. He pulled over next to me, but he never turned on the light. I was waiting at the light. It turned green. I turned, but he never pursued.
Okay, so why is there an evading with the vehicle then?
They got me in my apartment.
So you drove. So the couple of them next to you, and then you drove home.
I turned at the light whenever the light turned green.
Okay, Matt. Let's talk about March and April of last year. How many cases did you pick up during that one?
I think it's 2.
So let me walk you through it. So on March 12th, 2025, you got a case for possession of controlled substance, PG1, 4 to 200 grams. A week later, you got your second assault family violence with Crystal. And then on April 2nd, you got a PG-1 less than a gram. So within a month, you picked up 3 felony cases, one of which was violence. What was going on?
I was trying to go take our kids to school for the family, the violence, and I called the police, and I ended up getting a warrant for my arrest, and I turned myself in.
Okay. Do you have a problem with your problem with substances?
Not no more.
Okay. What was going on? What kind of substance did you have that month in March and April?
It was cocaine.
Okay.
Yes.
I think on your PSI you said you used cocaine when you were 18, but you didn't bring up that you were using cocaine last year. Why was that?
I just said I didn't. So I had told them on the possession that somebody was in my car and they left their bag in my car.
You think when you're talking to the interviewer, it's important to be upfront with them?
Yes, I did state that somebody left bags in my car.
But now you're telling them that you haven't used cocaine since you were 18, but you just admitted that you had it on you last year.
I wasn't doing it.
What were you doing with it then?
I was in my friends, and I was in my car.
So it wasn't your coke, it was somebody else's?
Yeah, correct.
Okay. Questions?
You've been tested for us at Center for with a CPS. Is that right?
Yes.
And have they tested you for drugs and alcohol there?
Yes, correct.
And they've all been negative. You have not used cocaine or any of that while you've been seen by CPS, correct?
Correct.
And if they tested you today, you would be negative, correct?
Yes.
Okay.
Just had a drug test last Tuesday, Friday, Saturday. Friday.
Okay. Do you think you could be successful if the judge put you under supervision of her probation officers, putting you through additional programs like you're doing now with CPS? Do you think you can? Are you willing to do that? Can you do it?
Yes.
Why do you say that?
I'm the main supporter for my family, and there's no income coming in for either the kids or my wife.
What do those children mean to you?
They mean everything. There's only 2 kids that I got.
You realize if the judge does put you under court supervision, any violation, if you would come back in front of her, I guarantee you it would not be good. You understand that?
Yes.
Do you still want the judge to grant your application for community supervision?
Yes.
Questions?
All right, this is what I want to know. And if anyone wants to answer the question, great. If no one wants to answer the question, that's great as well. I am trying to understand. One, he stated to me that for the CPS case, the children have not been placed with the mother who's listed as the complainant in this case. Children are placed with his mother. And that usually suggests to the court that there's some issue. Now, I know sometimes people will stand before me and say, oh, I lost my children because my partner was abusive or something like that. And usually that doesn't happen. So I'm trying to decipher and read between the lines what's going on here, because the state's stipulated evidence that everybody agreed to, we have some incident that occurred after his workplace. So I'm trying to figure out, how do we get from she goes to see you where you work, and I'm assuming, I don't know if the children arrive with her or not, everything is fine. Your new girlfriend or wife or whoever she is shows up. informs her that she's expecting. According to the stipulation, she said it was a great conversation. And then we have you going to the mother of your children's apartment and confusion results. And I'm just saying confusion instead of saying everything, but I reread the steps. And they're saying this happened at 7:50 on March 18th. What day of the week was that?
Which year, Judge?
2025. March 18th, 2025.
That'd be a Tuesday.
All right. So his testimony was that he was going over there to take the children to school. Was his testimony? I think that's what he said.
So
All right. So I'm just trying to figure out credibility here. So being at that apartment at 7:50 on March 18th, maybe he was there to take the children to school. I don't understand how we get from you're there to take the children to school to this incident happening, and then you're leaving the location. Were the children taken to school, or did you leave the location without taking the children to school?
I left the location without taking children to school.
All right. And so there is a lot that's missing from the stipulation that I would like answers to, but it was still sufficient enough to find you guilty of the offense. So how long have you been involved with Child Protective Services?
For a year already.
All right, over a year. So your rights have not been terminated? Did they give you an extension?
I got a court date in April and the deadline is for May.
All right. And so the mother of the children, do you know whether or not, because I know y'all will probably go to court together, do you know if she's completing her service plan?
Yes, she's doing her services as well.
Okay. And outside of court, have you had any, and when I say outside of court, outside of the CPS court hearings, have you had any contact with her?
Just to pay bills, basically. But she's not employed.
Okay. And when you say the pay bills, what bills do you mean?
Cell phone, groceries, food, whatever. She has like basically homeless without me. So she has no source of income.
All right. And what does your new wife or girlfriend say about that?
I don't no longer talk to her anymore.
No longer talk to who?
The friend.
Her name?
No, I mean the new woman that was in your life that's in the stipulations.
Yes, it was just a friend from an employer.
But it says she's pregnant. No, in the stipulated evidence, it says this new girl shows up, tells the mother of your children that she's pregnant with your child.
Mm-hmm.
And according to the stipulations, the mother of your children said it was a good conversation. Everything was fine. She leaves, and then you show up at her home on Tuesday. What you say is to take the children to school. So where is that person?
I don't know. She just calls me every once in a while, but she's not pregnant.
Okay.
Yeah.
Yes.
Let me ask a few more follow-up questions of Mr. Marquez.
Yes.
All right. So, Mr. Marquez, so this new assault family second charge is against Crystal, right?
Correct.
And you said you're not living with her?
Right now she's living at my apartment.
I'm sorry, what, living where?
She's living in my apartment where I'm paying.
Okay, she's living at your apartment.
So you are in contact with her?
Like I said, I have to, yes, I have to, because I have to pay the bills.
Okay.
Wow. This week. She's fine, like.
we'd like to show you the conditions of bond and the assault family second that we were talking about with Miss Crystal Vasquez. And on there, it explicitly says that there is a no contact order in place between Charles and the person named here. So he's just admitted on the record to you to violating his conditions of bond.
All right.
I do have another lawyer for CPS case. He supposedly picked up the violation for the no contact order.
All right. So who's that attorney?
I gotta look up my phone. If we do have to meet
Dale Hill.
All right. So we're going to take a short recess, and this is what I want attorneys to find out. It should be easy to find out. If somebody can call Dale Hill, or if somebody can have a CPS caseworker Zoom in here, because I want to see if what he's telling me is the truth regarding where he is in the CPS case. Because I would regret to leave children unsupervised, or they're going to be in foster care or something of that nature would happen if people have changed. So if somebody can get in touch with Dale Hill, get in touch with the CPS worker, and if there's no objection to them zooming in.
I'll just get the Zoom number. From
All right,
clerk,
thank
and I'll
you. And then I'll take this matter
have
up.
a seat. Oh, yeah.
Okay, friends, to be continued. The good news is we got about 2 hours worth of show yet, so we should be able to find out more. In the meantime, let's go to Louisiana, give the parole board a try.
The Committee on Parole is now at the Terrebonne Parish Detention Center. Good morning, Mr. Lacoste. Your mic's on mute.
Yes.
There you go.
Good morning, Ms. Renata. How are you today?
I'm good. Thanks for asking. Would you tell us your name and DOC number?
My name is Leopold Charles Lacoste II. My DOC number is 478688.
All right, thank you, sir. And I see you have counsel with you this morning. You have, I'll let you all, Ms. King, would you introduce yourself first?
Good morning, Teresa King here on behalf of Mr. Lacoste. We refer to him as Chuck. That's his nickname, but I am counsel of record here on the pending charges in Terrebonne Parish, as well as for the purposes of this parole revocation hearing.
Okay, and we also have Miss, is it Lizzie King?
That's correct, Your Honor. Elizabeth King, I go by Lizzie. I too am one of Mr. Lacoste's attorneys. I work with Teresa King, and we represent him in Terrebonne Parish and for purposes of this parole hearing.
Okay, great. Thank you. Yeah. So we are here for a revocation decision this morning. Mr. Lacoste, your case has been assigned to Mr. Tillis, so he'll read the allegations and ask for your plea, and then we'll proceed from there. Mr. Tillis.
Ms. Renata, it was to my understanding that this was being continued for us to be able to get people that I was supposed to have people here on my behalf and whatnot. And according to the paperwork that I was given, and when I'd spoken to my attorney over a month ago, this was, we were supposed to be requesting a continuance on this hearing for us to gather the information that we needed to proceed with this particular event.
I have no information in my records requesting a continuance. Ms. Teresa King, have you submitted anything?
No, ma'am. We were recently hired to represent him on the parole matter, although we did speak to him about it and attended the preliminary hearing at the jail. Miss Allison Leeret had informed us that a continuance was not likely because the parole board wanted to move forward. And then the latest information that I received before I was hired was that Mr. Lacoste had requested a continuance in writing directly. So I don't know if anything was submitted by Mr. Lacoste prior to us being hired.
Well, I think we have enough information to proceed this morning, Mr. Lacoste. So I'm going to go ahead and turn it over to Mr. Tillis.
Okay. Good morning, Mr. Lacoste. How are you?
Good morning, Mr. Tillis. Good morning, sir.
We have some violations that I'm going to read. You can plead guilty, not guilty, or with a statement. Violation number 3, you left the state of Louisiana without a written permission from your parole officer as evident of a tax documentation. Certain gambling winnings from the Golden Nugget Casino located at 151 Beacon Boulevard, Biloxi, Mississippi, dated 4/11/2025, and bank transactions on the following dates: 8/11/2024, 9/7/2024, 11/23/2024, 1/3/2025, 1/19/2025, 2/2/2025, 2/2/2025, 3/20/2025, 2/18/2025, 2/27/2025, and 4/11/2025. On or about 4/14/2025, you were engaged in criminal-like conduct as evident by your arrest by the Terrebonne Parish Sheriff's Office on charges of violations of protective order, charges of a violation of protective order, theft of $25,000 or more, felony, and exploitation of the infirmed, a felony. The current charges, imploding of this infirm, $25,000 or more, violation of a protective order in Terrebonne Parish. How do you plead? Guilty, not guilty, or guilty with a statement?
Well, to which portion of what you read, Mr. Tillis, is
If I may, Mr. Tillis, Mr. Lacoste and I discussed at length that there are mitigating factors to explain the technical violation of leaving the state without written permission. And so he may want to admit to those allegations, however, plead not guilty to the new criminal charges of theft or exploitation of the infirm and violation of a protective order.
Okay, you want to explain it or talk about it?
Yes, please. And Chuck, just give me a minute to give an overview, and then you will have the opportunity to provide specifics. So with regard to the allegations that he was leaving the state without written permission, he was previously supervised by a parole officer who gave him leeway. He had written permission to leave to go see his mother, who lives on the Gulf Coast of Mississippi, and went to see her multiple times with permission of the parole officer. The parole officer told him, "You don't have to ask for written permission every time. I know you're coming back. It's all good." Then he got a new parole officer, Allison Liebert, who was much more strict, black and white, with her following of the rules, and you need to get written permission every time you leave the state. And the summary and recommendation that was submitted by Ms. Liebert actually has included a statement from Dr. Linda Thibodeau, who is Chuck's mom. As it pertains to the criminal charges, Mr. Lacoste was accused by his aunt of using her debit card or bank account without her permission, although they lived together for multiple years, and she permitted him to use her account in a variety of circumstances. He never used it without her permission, but when other family members discovered their arrangement, they became upset and involved the police, believing that their mother had been taken advantage of. After his arrest for theft or exploitation of the infirm, a judge issued a no contact order as a bond condition. Mr. Lacoste never bailed out and therefore was never subject to said bond condition. And when he was accused of violation of a protective order, it was because there were allegedly phone calls made to the alleged victim. No threats, no harm, but a phone call from the jail from Mr. Lacoste to the alleged victim or family member. And that's the extent of the violation of a protective order, which we believe is not a valid charge because there was no protective order in place. There was no court order stating that Mr. Lacoste should not have any contact with a specific person. If there was an order, that order was not served on Mr. Lacoste. Having no notice of said order, he should not have the criminal charge of violation of a protective order. All that also should be, it should be noted that he's innocent until proven guilty, has not been convicted of the new charges against him. And we would ask that this board not revoke his parole on the basis of mere allegations.
What about leaving with his new parole officer without written permission?
Mr. Lacoste, do you want to explain?
May I speak? May I speak now?
Yes.
Mr. Tillis?
Yes.
Okay. Yes, sir. Okay. So I provided to my attorney, first of all, my attorney does have some dates that Ms. Lerat claimed that I was away and hadn't gotten written permission to leave, and that I did actually have written permission to leave. My attorney has copies of that in her file that she had, on some of the dates you read out, said that I had left without written permission when I did have written permission. The other thing, sir, is my father got cancer, okay? And my prior parole officer allowed me to come and go, yes, sir. And I always worked, I always came back. I never did, as far as any of that's concerned. The thing is that also some of the time now, yes, in fact, I did have a player's card with the casino, but my aunt that I was living with was taking trips to the casino and using my card to get the free play off of it. And so were my parents. And that's why I asked for my parents would say that as well, that they used my card from time to time to get the free play off of it when they would go there. But the other thing was that my attorney also has a copy of my call log to Miss Allison Lerat from my cell phone, because she's in possession of that and has been since my arrest. And the thing is that I did try to make contact with Miss Lerat, and every time that I did, and she didn't call me back, Miss Lerat was out for surgery. She was out for several other things that I didn't know about until later. But in any case, I had also requested Mr. Jason Knockin, who was my prior parole officer, to come to talk to you as well. I mean, about all of this. My father came down with cancer. He's 88 years old. My mother needed help. She's 85. And yes, I tried calling Allison Lerat. And yes, I would go to my parents' house. And every time I went to my parents' house, I did work around the house that they could not do, and then came back to take care of going to work here. And so, I mean, I hope I'm answering your question, but I'm trying to give you the explanation. I was not trying to not ask. I was not trying to not follow Miss Lerat's request. But when I called for Miss Lerat and Miss Lerat wouldn't return my phone calls, I don't know what else I was supposed to do, sir. I mean, my father was going through chemo and radiation treatments, and he's, like I said, he's 88 years old, and they needed help. And
So you were not going to the casino?
Mr. Tillis, I did go to the casino, but I didn't go to the casino all that as many times as Miss Leverett said I did. And yes, I did. I went to my parents' house, and sometimes my parents would say, hey, let's go get dinner or whatever after I did work around the house. And maybe we went by there once or twice when I went to their house. But I did not go to like I said, this is all coming from information from a player's card and all that. And my parents used the free play that I got from that player's card, and so did my aunt when she would go. And so I'm not saying, Mr. Tillis, that I didn't go, because I did. Yes, sir, I did go, but I didn't go as 10 times or whatever she's got on there that she's saying that I left and went to a casino. That was not what was going on, sir.
Okay, and you said they were supposed to come and verify that? Your aunt, your mother?
Well, my mother would be happy to testify under oath that yes, they've used my player's card. My aunt used my player's card. But the thing is that when they pulled the record from the casino, it showed every time that it was being used. So it was me there, and that was not the case, sir. And on those dates, like I'm saying, my attorney has some permission slips for me to go to Mississippi to my parents that she's accusing me of leaving the state and not having permission. I have no problem, no issue telling you the truth about the fact that, yes, sir, I did do that, but not like that she's saying I did. Okay, that's not how it happened. And from what I understand, that me having done that, that was a technical violation, not a revocation.
Okay.
I mean,
and if I may add something briefly, Mr. Tillis, Miss Leverett and or Trina Williams, who participated in the preliminary hearing, did speak with Agent Jason Knockan, and it is in the summary that he provided the following statement. As far as I know, the offender remained in compliance with no reason to violate him for absconding supervision. And his mother, Dr. Linda Thibodeau, also provided a statement and said that her husband Donald was diagnosed with cancer, that Chuck came and he tried to call Allison repeatedly and did not always get a response. And his mother, Dr. Thibodeau, also provided a statement regarding her sister, June, who is the alleged victim of the theft or exploitation of the infirm, indicating that June had never said anything about a financial issue and that she is now listening to her daughter, Shelley, who prompted the criminal investigation. So the witnesses are not present here to testify. In my research in advance of this hearing, I did not find a process for subpoenas, and I apologize, this is my first time handling a parole hearing by Zoom, but certainly Miss Linda Thibodeau and her husband Donald would be present if they were tech savvy or were ordered to be here.
Okay, all right, thank you.
Thank you.
Let's move on to the next violation. Violation number 4, on or about 4/14/25, you were engaged in criminal conduct as evident by your arrest of Terrebonne. Did I read that?
yes, sir, you did read that?
Yeah.
Sir, I am not guilty. I am not guilty of violating any protective order because I never had a protective order. And even furthermore, I never spoke to my aunt since I've been arrested. And so don't even, none of it makes any sense. The judge that set my bond said that if I bonded out, a condition of my bond was a no contact order with my aunt. I got arrested. And furthermore, I got arrested. I did make an attempt to make a phone call to my aunt. I did make an attempt to talk to her, but that was before I'd even been told about the bond, the condition of bond. And so then they said that I violated a protective order and added another $25,000 to the bond. But then I couldn't bond out because Allison put a parole hold on me. And so I never bonded out, sir. I never violated any protective order, sir. I never did. And once someone told me, I never even attempted to call my aunt again. I didn't.
I hear you. Miss Liz, you want to address any of this?
I believe that that Ms. Teresa King has addressed everything very thoroughly. I'm mainly going to defer to her and to Chuck's testimony. The attempted call to his aunt was before he was aware that there was a protective order in place. You don't know what you don't know. And afterwards, he was incredibly diligent. He's always been very diligent, and he was diligent in following the instructions from that protective order. And then just to reiterate, I know that we've passed this issue already, but just to reiterate, even if he went to a casino one time, that is just a technical violation. And as Chuck and the other Miss King have noted, is a technical violation, not a reason to revoke his parole.
Thank you. At this time, I'm going to ask for an executive session, please.
I'll second. Any objection?
Nope.
All right. Mr. Lacoste will be in executive session for a few moments to discuss confidential matters.
Ms. Maranatza, Ms. Renata?
Okie dokie. While they do the executive session, let's go back to Judge Boyd because I believe that the guy we were watching earlier is back in play now.
Both attorneys told me that they've spoken to you, or Mr. Wolf has spoken to you. I'm just trying to find out specific information. Mr. Marquez told the court under oath that he is doing well with his CPS case, that he's been having visitation, and I don't know if the mother's doing well or not. I don't want to derail a reunification or have the children just out with non-family members if I were to send him to prison, if he's doing well.
Yeah, Judge, according to the last permanency hearing we had, he was in compliance, and we're set for trial in May.
Okay. And can you just tell me, and we're not on the record or anything, how is the mother doing?
Let me see real quick, Judge, if I can look at the compliance. I'm trying to think off the top of my head with this. I was trying to look at this report to see if she was in compliance or not.
And could I have the Marquez file back, please?
Well, of course, as soon as
There's no clip I didn't.
No problem. Thank you.
Judge, I apologize. I'm just trying to bring this up real quick.
Nope.
Generally, okay. Per the permanency hearing, it was the mother demonstrated adequate and appropriate compliance with the service plan.
Okay. All righty. And has your client been having visitation with the children?
Yes, Your Honor.
And are the children placed with his mother?
Yes, with paternal relatives.
All right. Thank you so much, Dale. You've
Thanks, Judge.
questions.
I don't get on that side much anymore, so I'll pop in next time.
At least stop by to say hi.
I'll do that. Thank you, Judge.
All right. Thank you. Have a good one.
See you. Thank you.
All right. Are you all ready to proceed?
We are good.
All right. We're back on the record in 2025 CR 015638 and 2025 CR 01263, State versus Charlie Marquez. Can I have parties re-announce?
Brandon Brady, State.
Warren Wolf and Mr. Marquez.
And you're Mr. Marquez. All right. We were not on the record, but we did have Mr. Marquez's CPS attorney zoom in. And as an officer of the court, he presented the court and both parties with updates on the CPS case. And according to his rendition, Mr. Marquez is in compliance and that the children are residing with the paternal grandparent. All right. So this is what I want to stress to you. There is a no contact order, and the no contact order is in force. The only exceptions usually for a no contact order is if you are in court. So that is the only contact you can have. And you can pay bills for an apartment that somebody is staying in without having contact. You either send it by check, money order, but you do not need to go to the location. You can pay any type of utilities. And the last time I lived in an apartment, I think sometimes the utilities are included with the payment or it may be separate. But if your name is in the utility bill, you can pay that online. You are not allowed to contact her outside of being in your CPS court hearings. Do you understand? If you do that, you will violate any probation that I give you. And then you're looking at doing time. And when you're looking at doing time, maybe your parents will be able to take care of your children, maybe not. They may end up with their mother. And somebody else, some other man will come in to raise them. Do you understand?
Yes.
Judge, would you be willing to entertain a motion to modify that no contact order?
No.
If that's the solution, I can do that.
Yeah, no. All right. So this is what the court is going to do. Let me see. I'm trying to find your application. Did he apply for deferred adjudication?
No.
Just regular? All right. This is what the court is going to do then. End cause number, Odyssey again. 2025 CR 015638. Probation, are you ready? Court is going to is finding you guilty. Court is going to sentence you to 8 years in the prison, suspended and probated for 8 years. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 45 days. No employment as a home health care provider or with minors. There's to be CPS compliance. There's to be no contact with the complainant. There's an affirmative finding of family violence. There's going to be GPS tracking, waive fees. That is to be installed no later than February 10th, 2026 at 3 p.m. This run concurrent with 2025 CR 012673. 2024 CC 737959, 2025 PF 09446. Taking consideration 2025 CR 011814, 2025 CC 004665, 2025 CR 011499. There's to be field visits one time per month until further notice. There's 200 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service hours will be deemed satisfied. CPS parenting classes, which they should have ordered, will be acceptable. Probation, is there anything else with regards to that case?
Judge, the only concern that I have was that it was mentioned that he's supposed to have some type of surgery on the 13th, I believe, or the 16th.
That is correct. When is your surgery?
13:30.
All right, so the GPS is to be installed after clearance, after medical clearance.
Thank you.
All right, and then there's to be the BIPP course.
I think he's already either taken it or enrolled.
All right, he'll need to provide proof of that to probation. And probation, he's currently in a family violence course. That family violence course will be acceptable to the court. And that cause number, did you review the document entitled Trial Court Certification of, state your excuse.
Thank
Thank you. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it in that cause number?
Yes.
Because it's a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. We're moving on, and cause number 2025 CR 012673. Court is finding you guilty. Court will sentence you to 8 years in the prison, suspended and probated for 5 years. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors. There's to be installation of GPS, and that will be tracking, waive fees, and that's to be installed after medical clearance. And Adriana?
Yes, sir.
I know you all have to put times in there.
Yes,
So
sir.
it's GPS until further notice.
Yes, sir.
This will run concurrent with 2025 PF 11276. And probation, I believe that cause number is the CR number that we just did. Taking consideration 2025 CR 011814, 2025 CC 004665, 2025 CR 011499. There's to be 200 hours community service restitution. You're going to take the defensive driving class. Once that's completed, the community service hours will be deemed satisfied. There's to be field visits one time per month until further notice. Probation, is there anything else? And I'm sorry, there's a $1,500 fine and that will be probated. Is there anything else you need from the court to be successful?
Thank you.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? Yes. All right, we can go off the record. Here's the thing. In this court, to be successful on probation, communication is key. If you had a misunderstanding about the no contact order, you now know you're not allowed to have contact with her unless you're in civil court. And what does that mean? That means you're not talking to her in the hallway, because she has an attorney, you have an attorney. You are to be in the courtroom. That's it. You are not to go to your other apartment. If that apartment is in your name and you're paying bills and you're being nice and allowing her to live there, you can pay that bill, send it in to the apartment complex. You can pay the utilities online, but you are not to have any contact with her while that protective order is in place. Do you understand?
Yes.
Is there anything you do not understand? All right, good luck to you.
Thank you very much, Judge.
Thank you. Oh, do I have the cases that were taken in consideration?
I believe Mr. Prager is putting that together.
All right, thank
He
you.
also has a matter in County Court 4 I need to.
All right,
deal
thank
with,
you.
And I'll bring him back to deal with probation.
Oh, you may want to let him deal with probation now. Probation would want that. Probation? He's trying to take Mr. Marquez to misdemeanor court. I told him, no. All right, who else is ready?
Yes, I have Jay.
Okie dokie, let's go back to Louisiana. Looks like they're back from executive session.
I'll turn to regular session. It is 9:55 a.m. What did you want to say, Mr. LaCoste?
Just to Mr. Tillis. Mr. Tillis, also Ms. Leverett put on that paperwork that I was given that I was in arrears for payments. If you look at the record, also, I was always paid 6 months in advance on all of my fees. I never, ever went past due on a fee until I became incarcerated. I am not out. I was not. I was doing everything the way that I should have been doing it, except for the fact that I did go to a casino. And I just would hope that you please take that into account, sir.
All right, I think we're ready to vote. Mr. Tillis?
My vote today is going to be to revoke because of violation number 3.
What is number 3, sir?
Mr. Prater?
I concur, violation number 3, reference to absconding, being out of state.
And I agree, Mr. LaCoste. I've heard everything you said, but you did leave the state without permission, which is a violation of condition number 3. So today, sir, your parole's been revoked. I wish you well on your pending criminal charges. You'll be able, depending on what happens with that, you'll be able to reapply for further consideration by this board. Good luck.
And that was going to be my question. Once his time is calculated, he will be eligible to request early release through parole again, correct?
Yes,
It'll be at the discretion of the board after serving a year.
Denied.
To the surprise of nobody, so he doesn't realize that when there's a microphone nearby and he's hitting the table, it makes him look even angrier than he probably is. That's something somebody should have told him ahead of time or told him during, like, hey, stop it, dude. But, you know, whatever. Let's go back to Judge Simpson. Let's not, because he just cut his feed. Judgy. All right, let's do this then. Let's go say good morning to Judge DeSanto.
Hands on your pockets.
All right, and counsel?
Hello, Your Honor, John Bull, Law P 30758 on behalf of Mr. Hernandez. Please put your name on the record.
Okay, and good morning. Please keep your hands out of your pockets. Today is the date scheduled for show cause on this matter. Your client was ordered to pay fines and costs, and it appears as though he paid so he was ordered to pay $4,605 for fines and costs on his 3 misdemeanor convictions and 2 civil infractions. And it appears as though he still owes $4,313.20. So if I had to guess, there was a bond posted that was applied and your client didn't make any other payments. But I could be wrong.
I understand that, Charlie.
So, Mr. Hernandez, have you made any payments?
I think the last payment I made was October or something like that.
First of all, sir,
Speak up.
we have to be able to record what you're saying. So then you need to make sure you're keeping your volume up, okay?
Okay. The last payment I think I made was October,
October what?
last year,
Of 25?
20,
How much did you pay?
like 50 or something. 50.
Okay, and was that as a result of getting your notice for the show cause hearing? Please keep your hands out of your pocket, sir.
What was the question?
Was that because you received a notice for the show cause hearing?
Well, I believe, and I could be wrong, that when he was here previously, because he's not on probation, that there was a payment plan entered. And I believe he made one payment of $50. That's what he informed me. But since that time, he's made no payments. And
Well, who was he placed on a payment plan with? Because
the docket is not very clear.
well, what's clear is that your client was on probation
Correct.
and he was discharged from probation January 9th of 2025.
Correct.
It appears as though he was discharged from probation but not having made a payment. But I'm going,
That's,
Autumn, is it possible you can pull up GIS to see?
and that's what he indicated to
Okay,
me.
hold on 1 second, Council.
There was being said earlier on, Jay would increase the state date, there's.
I'm looking to see if there are any notes in the computer that indicate a payment plan and what that payment plan was.
It was paying like 50 a month that started with it looked like.
Okay, when was the last, before October, yes, I see $50 per month beginning December 1st of 23. How many of those did he make?
My payments of 50, he made $100 payment. $55 payment, so 24, another $50 payment. That was like something. October 24, another $50 payment. 9 of 25 is $35. That was it.
Okay. So, sir, thank you. If you were unable to continue with your $50 payment a month, did you communicate into the court asking for a different payment arrangement?
No, I didn't.
Okay. So what's your proposal?
I can make a payment tomorrow, then, I would like to, if you can, on the $50 payment, I can say payments this time around.
Well, okay, you're saying continue paying it, but you really weren't paying it to begin with, so it's not really continuing. You're asking to resume it?
That's correct, John. Yeah, correct. He was going through a number of problems financially, not himself so much as his mother. He was required, he had to help his mother out, ended up paying all of the taxes on home, as well as assisting her in other areas. At least that's what he's relayed to me. He understands he should have called the court and told him, hey, I need some more time or to pay this money. I know I owe it to you.
Right, I mean, we would have worked with you, sir, right? And I can appreciate that you're helping your mom out, but then that's to your own detriment.
Right.
Because you didn't communicate that to the court. So how much are you paying? You don't have anything to pay today.
I pay tomorrow. I don't have nothing right now.
All right, where are you working, sir?
It's called Hellingsworth. They do car parts for Ford.
And so you're paying $50 tomorrow, and then it'll be $50 every month after that?
Yes, ma'am. Yes, Your Honor.
All right, are you getting a tax refund?
I haven't done my taxes yet.
Okay, do you typically get a tax refund, sir?
Yeah.
Yes?
Yes.
Okay, so can you commit to a portion of that to pay on this, it's a pretty significant balance. That's why I'm asking that, sir. All right, and so how much do you want to commit?
300.
Okay, all right. Okay, so then what we will do then, sir, is we will hold the show cause in abeyance, and it will be back on the docket if you miss a payment. Okay? If you'd like, sir, you can stop at the window and you can get information about paying it online. So then you don't have to worry about coming up this way if you're working or something.
Okay. Thank you, Ron.
All right?
Thank you.
You're welcome. Have a good day. We are on the record in the matter of the City of Wyandotte for Stephen Maritho, 251570.
Good morning, Your Honor. Edward Sutherland, appearing on behalf of the defendant, Mr. Maritho. Please try to sit still. Speak clearly for the judge. Give your name, sir.
But you have to unmute first.
Well, you got to unmute first, sir. Glad he's not a pilot, Your Honor.
Stephen Maritho.
Okay, and good morning.
Good
And
morning.
so, but it does not look as though your client's at the airport. I think he still might be at work, but I'm not sure, unless he works at the airport. I don't know. Oh, no,
Yes,
he works for an airlines or something, right? You said?
Yes, American Airlines.
Okay, so, Mr. Maritho is on Zoom because he's stuck out of state for work purposes. Mr. Zelnak was at court yesterday on behalf of Mr. Maritho. And Mr. Maritho was expected back yesterday. However, due to weather issues, Mr. Maritho was stuck in North Carolina, correct, counsel?
Yes, Your Honor. He's actually stationed at that airport for American Airlines. He said there's more flights and more work. He's originally in Detroit. They moved him. So he commutes from Detroit to Charlotte every week and comes back home.
Okay, so let me also state that I do know your client. I haven't really seen him or otherwise. He did send a message asking if somebody misses a court date or they're out of town, how does that work? That was before you were here yesterday. But that's about the only communication I think I've had with your client in the last couple of years.
I don't have a problem with this court hearing the case. I know it's been some time, and I know that the court's fair. And Mr. Maritho, I don't have a problem with Judge DeSanto hearing this case. Do you?
No, not at all.
But one thing I want to make clear, Mr. Maritho, you may have had children on the same team, coached the same teams, things like that. During the pendency of this case, you're not to communicate with the court's relatives by text or any other message or method. You go through your counsel. Does that make sense to you?
100%. Yes, sir.
Judge, I'm sorry that happened. That's before he spoke with me, so that would have never happened.
Okay.
And we'll waive the reading. Ask court stand in mute, enter a plea not guilty, and set a pretrial date. And I'd like to do it next Wednesday because we've got a plea offer. Can you be here next week from work, Mr. Maritho, for Wednesday for court?
I will try and do what I can. The next Wednesday, is there, yeah, if that's what I need to, I mean, a little bit more of a notice would be easier.
Let me ask this question. So the only day that the Wyandotte prosecutor is at the 27th District Court is on Wednesdays. What is your work schedule? And are you at work? Do you work during the week out of state?
Yes. Typically, as of right now, there's a new bid coming out, but my bid right now, I have Friday and Saturday off.
Okay. So counsel, I'm not going to put your client's employment in jeopardy. There are many individuals that are out of state for work. We will allow your client to Zoom in. He doesn't have to somehow make his way back for Wednesday and then go back to work. So we will allow your client to appear via Zoom for his pretrial.
There should be a plea in the file. I would do it today, but you know how I let people be here in person, so.
Well,
And I know, and I appreciate you extending that courtesy.
so we will schedule this
yes, thank
for
you.
February, you're welcome, February 11th at,
I'm here 8:30.
well, I guess we'll just do 8:30. Does that work? Okay. Whatever you say. Okay, so 8:30 a.m. as to bond.
We can't post a cash bond. They had asked for substantial.
Actually, you did post a cash bound already.
We did, okay.
On November 13th.
Oh, yeah.
25.
Okay.
Okay,
Been a delayed complaint. How did it get so far in the middle? Because I found out about 3 weeks ago, Mr. Morito. Needs to be more.
well, no, so the offense date was November 7th. Let me see here. Then it was set on the docket and mailed out November 18th for today's date.
All right, very, all right.
Well, actually for yesterday's date.
Judge, then I thought it was like Spirit never notifying you when the flights are canceled. I just wanted to know if there was some communication issue. So, Your Honor, I'd ask you to continue that bond, usual conditions, no drugs, alcohol, no drinking, no illicit narcotics, and when he comes in, I'll have him list what prescription drugs he's on. It was on any.
All right, and so Mr. Morito, if you were to test right now, what's in your system?
Nothing, ma'am.
All right, and I do show that in 2023, there was a matter of counsel, and I believe that I disqualified on that matter. But that was, I believe, well, that was because our children were still in school together, and they're not, they've graduated. So I just wanted to just state that for the record.
I have no problem with that. Thank you, Your Honor.
Are you randomly tested for work purposes, Mr. Morito?
Yes.
And how long have you been working at your current employer?
Just, it'll be 2 years in May, ma'am.
All right. All right, the court's going to, if I didn't already indicate, you not to possess or consume any alcohol or drugs unless prescribed. And I'm going to also order random testing. So I need you to email into probation, and then they will communicate with you how to set up the random testing. So you can, I will also make a note that defendant works out of state Monday through Friday. And we'll need to locate testing facility. So you'll have to just communicate with probation, sir, regarding the testing out of state. All right, so email into probation by 10:30.
Judge, I'll walk over to get the probation email from him and I'll text it.
Okay, very
Thank you,
good.
Judge.
Thank you. Have a good day.
Okay, folks, just a reminder, as I said earlier, as we enter the fourth hour today is just going to be more court. Again, I have a crew here working on some stuff at the bunker, and I keep getting pulled away, so it's not a good hour for me to try to do any kind of discussion or commentary because it'll just get interrupted. So let's continue with Judge DeSanto for a little bit.
Okay. And counsel, today's the date scheduled for the probable cause conference, and there's a request for another adjournment.
Right. We've requested certain discovery from the prosecutor's office. They've not produced it. They were going to follow up with their officer in charge. That's what I understand from our conversation.
All right, well, let's see, January 15th, we adjourned this so that council could review discovery. We adjourned it to January 22nd. January 22nd, the PCC was held, and indicates defense did not receive digital discovery. And now here we are 2 weeks later, and you still don't have that?
No, I don't. The discovery, I sent a list 2 weeks ago of everything that was missing.
And so council, when did you follow up?
Well, I followed up the day of our last court hearing with an email.
Was there any follow-up last week?
Oh, let me do a search. I definitely. Yes.
Bobby, can you please grab Mr. Mohammed?
Yes. Well, let's see. January 22nd was our last court date. So another one. Let me see here. February 3rd.
I've sent a few emails.
Good morning, counsel.
Good
Will you
morning.
please place your appearance on the record?
Good morning, Your Honor. Mohammed Mahmoud.
Okay, so this is regarding Miss Ariana Brown Jones. So Mr. Godwin, you indicated that you, on February 3rd, you sent a follow-up 2 days before the court date.
Yeah, another follow-up then, yes.
There wasn't any follow-up last week or the week before?
Well, there was a
Well, the 22nd.
email. Yeah, that's
Okay.
correct, Judge.
Mr. Mohammed, why has the discovery not been sent over to Mr. Godwin? This is now the third request for
Yes.
adjournment for discovery purposes.
So, Judge, we did send 2 requests now to the OIC. I think the OIC on this case was on vacation, if I recall correctly.
He's on vacation this week.
Oh, he is.
Yeah.
I know last week he was as well because he had a case last week that involved him, and I wanted to turn over restitution to him. It's that co-defendant case we had with restitution, and he was not available on that day. So I think he's just unavailable right now.
Okay, but doesn't the detective upload the discovery onto evidence.com when they submit their warrant request?
Yes, so that discovery was sent to the defense. It's the digital that the defense is missing.
So they don't, so the police
discovery
department,
packet is
the police departments don't upload digital discovery, only the paper discovery?
they're supposed to, but they didn't on this specific case. And so I sent an email, I think last week, to the OIC informing them we're missing digital, can you please upload? And then I sent a follow-up email, and we still don't have it. So we're just asking for a 1-week adjournment. There's a stipulation with defense, my understanding. And I think it will be resolved. And if it's not resolved, if I don't hear back by the end of the week, I'll reach out to another detective. But
Well, or there can be some communication upstairs with a detective right now, because here's the problem, right? So now this matter has been pending, it's a month, and there was 1 request to adjourn on January 15th so that defense could review discovery. January 22nd, defendants did not have all digital discovery, so we adjourned it to today, and now it's a request for an adjournment for the exact same reason, 2 weeks later.
And Judge, we're prepared to move forward to the preliminary exam. I understand defense may want to review that, but we are prepared to move forward. Discovery is an ongoing process, so I think we can move forward for purposes of the exam. But I don't have any objection if defense wants to adjourn. However, I understand the court's position.
Have you been able to go upstairs to see when Detective Carr is back to make sure you're going to get this information before next week?
No, I did not go upstairs, but I can. And I'm sure other detectives may have access to the digital to ensure it's uploaded.
This is the final adjournment.
Thank you.
February 12th. What time works, Ally? Autumn, sorry.
10 a.m.
10 a.m. Does that work for you, counsel?
Sorry, 10 a.m. Okay. Sorry, Judge. Let me see the time. I have an exam at 10 a.m. next week. I could do 11 or earlier.
Does 9 a.m. work for us?
Do 8:45.
Does 8:45 work for you, council?
Yeah, yes, that would work. Yes.
All right, 8:45 a.m. Bond and conditions are continued. Thank you. Have a good day.
Thank you.
Let's go off the record for a moment. Okay, let's see. We have a lot of individuals in the Wayne County Jail.
We check to see with people. We challenge.
We did.
What's that?
We have.
So we know who's on which camera?
Well, up there, and we know who's supposed to. Elvis Sabah is supposed to be.
Yes. Okay, so let me just request that they don't turn on their cameras and we can, okay. I think that's Mr. Sabah. The individual that just turned on their Wayne County Jail camera, are you Mr. Sabah? Please hit unmute. Thank you. Are you Mr. Sabah?
Yes, Your Honor.
Okay, very good. Thank you. Do you need a moment to speak to your attorney, or did you speak to your attorney while you were, did she visit you there in the jail?
Yeah, I spoke to her last night.
Okay, very good. All right, it'll be just a few moments, sir. Do you want me to rename Mr. Sabah in this one, or do you want to?
All right, well, they get stuff sorted in order to better proceed. Let's go back to the parole board and give them another shot.
Open right ready when you are.
Good morning.
Good morning.
Good morning, Mr. Landry. Do you have any paperwork there with you this morning?
No, ma'am.
Okay, we're gonna put a form up on the screen. I want you to tell me if it's your signature at the bottom of the page. It's called a parole revocation questionnaire. You filled it out prior to your preliminary hearing. See, it's come. You see it?
Yes, ma'am.
Is that your signature down at the bottom?
Yes, ma'am.
All right. It was determined at your preliminary hearing based on those questions that you're not eligible for us to appoint you a lawyer today. So you're ready to proceed with that one?
Yes, ma'am.
Okay, good. Your case has been assigned to Mr. Tillis. I'm gonna turn it over to him.
Good morning, Mr. Landry. How are you?
I'm all right, man. How about you?
Good, good. We have two rule violations that were violated. I'm gonna read them to you and you can say guilty, not guilty, or with a statement. Violation number 4, it's alleged that the subject is in violation of the condition in that which he was arrested on 10/29/2025 by the Livingston Parish Sheriff's Office and is being charged with theft, 2 counts, unlawful distribution, and tampering with surveillance. How do you plead?
Not guilty. Those charges were rejected.
Okay, we'll just go through this and then we'll let you talk and elaborate on it. Guilty, not guilty with the statement.
Yes, sir.
Okay. On 12/18/2025, the defendant entered a plea of no contest to the charges: theft under $1,000, theft under $1,000, and resisting an officer. Case 25 MISD 13. The state dismissed the count 1 and count 2. The court accepted the plea of the sentence of the defendant as followed: 49 days parish prison, current with any other time. The court deemed this matter satisfied. Rule number 10, Records reflect subject failed to make payments toward monthly supervision fees and currently $882 in the arrear. How do you plead?
I had, can I make a statement on it? All right,
Guilty or not guilty? You're saying not guilty with a statement?
well, I had just came off doing a 90-day tech for that violation, and the resisting that had came, I had got that charge before I ever did the 90-day tech.
Okay.
Had you ever made any payments? Ever?
Yes, ma'am. A couple, I think 2.
Yeah. So you were released in July 1st of 2024. So regardless of the 90-day tech, this says you failed to make any payments ever.
I paid the processing fee.
Okay. Yeah, which is different than a supervision fee. So I get it. I'm sorry.
Well, that's good. Thank you for clearing that up. So you plead guilty or not guilty to the inderailment of $882?
I guess guilty with a statement.
Okay, go ahead. Tell us about it.
I had just served a 90-day tech for that violation.
Okay. All right. Any of my colleagues have any questions?
Mr. Landry, you haven't been doing very well on supervision, have you?
No, ma'am.
Why is that?
Really, drugs. Yes, ma'am.
And I know you've been offered many opportunities to address that issue, and you don't seem to have any interest in doing so.
Yes, ma'am. I do now. I've been thinking about it, and my grandmother, she just got in a wreck. She got her neck. You can ask my parole officer, Mr. Smith. She got a broken neck, and 3 broke ribs, and so it kind of, I guess, been a wake up call for me.
Yeah, I'm sorry to hear that about her. I don't have any questions. I just wanted to hear you talk a little bit about that. I think, are you ready to vote?
Yes, I am.
All right, Mr. Tillman.
My vote today is going to be to revoke for violation number 4.
Mr. Prater.
I concur.
And Mr. Landry, my vote today also is to revoke. I find you guilty of violating condition number 4, the criminal activity. And so today your parole is being revoked. And I do hope that you're able to get some help with your substance abuse issue before you release on your full term date. Good luck to you, sir.
I got to do to my full term date?
Denied.
Sadly, Wolverine will be in prison for a while. I'm curious if they're going to order a decline. That is my only concern and question. Back to Judge DeSanto.
Okay, and so the camera that I just requested to unmute, please hit unmute. All right, are you Mr. Cross?
Yes, Your Honor.
Okay, so your camera D. I think that's D. Does that say D? Yeah, okay. Okay.
Oh.
Actually, okay, so I just threw, because Mr. Cross and Mr. Benefield look slightly similar, I just threw their last names at the end of the camera. Yeah, I'm just. So we know that. Let's go off for that one too. Okay. Do you want me to wait to check in the other people that are in the waiting room, or do we want to keep going? What's that? All right. Okay, let's go. Well, we're not going to do this one, Mr. I'll pause that in here. Okay. Are these all Mr. Goldberg?
No, that's too long.
Okay. Ms. Patello's not in here. I'm striking out. Mr. Quartz, he's talking to the prosecutor. Kavanaugh. Is Ms. Kavanaugh here?
No.
No. Just? Oh, okay. If you can, no, if she can come in and I can handle this one. Okay. Okay.
Your Honor, can I be put in the waiting room to see the prosecutor?
You're looking for.
We have a 1:30 exam.
Okay, so is that exam not going?
We probably would like to waive it if we possibly could.
Okay, so
The judge and I've been texting with the victim. It's just nothing.
let me let Mr. Hunt, would you mind letting Mr. Mohammed, is that Mr. Parker? Yes, can you let him know that Mr. Parker's here? There's you're representing Mr. Wheatley, correct, Mr. Parker?
That is correct, Your Honor.
Can you just let him know that he's on Zoom and would like to be in a break? Oh, Mr. Mohammed, Mr. Parker is on the break, on the Zoom for the 1 o'clock exam. He would like to speak to you in the breakout room.
All right.
All right, counsel, I just would like to ask though, did you try contacting Mr. Mohammed at any point before right now so that it's not tying up our Zoom?
No, I didn't, Your Honor. I was waiting for a reply on a request for reducing the charge as the OWI case. It never did come. So we decided last night we're gonna waive the exam.
Well,
So,
okay.
if you want me to come out there and do it, I can do it, but it's up to the court.
Well, the problem is that we have one Zoom operator here and multiple boxes, and we need to make sure we're putting, we're utilizing our time effectively as best as possible. So
I understand.
All right, it'll be just a few moments, and then Mr. Mohammed will put you in a breakout room.
I think Judge DeSanto just summarized it well right there. They need to make sure they're using their time wisely, and it feels like they're struggling with that this morning there. So let's move on. Jason Elmore, he's usually a little more judicially efficient. And, you can't make this stuff up. I go there because he's judicially efficient and he's not ready to go, but it looks like he is now.
In Oxford County, we're taking up 2 files. Each file is entitled People of the State of Michigan versus Nathan Douglas O'Brien. 2 case numbers are 25-13990FH and 25-13991FH. Appearances from counsel, please.
Nate Carnes on behalf of the people. Bill Burdett on behalf of Mr. O'Brien.
Thank you. Before the court also is Mr. Kevin Stubbleman. He's an agent from the Michigan Department of Corrections who is here today serving as the probation officer. And joining us this morning from the Wexford County Jail is the defendant, Mr. Nathan Douglas O'Brien. Mr. O'Brien, are you able to see and hear the court today, sir?
Yes, Your Honor.
All right, thank you very much. Just a minute, catch up on some paperwork here. We're here today to address a request and summons for a probation violation that was filed back on October 15th of 2025. It included 2 allegations, both having to do with allegations involving failing to comply with the Sex Offender Registration Act here in the state of Michigan. And it was released on a personal recognizance bond, like on November 6th. The matter was set for an informal hearing initially on November 14th of 2025. And that was appointed to assist. Were you appointed or retained?
I was appointed, Your Honor.
All right, thank you. We also appeared on that 14th, and the parties each waived their 14-day rule under 6.445. And the court therefore had it set for a hearing. It was initially set for December 8th of 2025. And then it was reset after that for today's date. And that's why we're here. Mr. Carnes, you know what we're doing today?
Your Honor, I think defendant will be pleading guilty. The people have agreed to recommend time served and continue probation.
Did he pick up a charge? I'm sorry, did he get a conviction related to this?
Your Honor, he's going to be arraigned on that today at 1:30. I have made an offer to Mr. Bardette on that file, although he's not technically his appointed attorney on that file.
And why is what's he in jail for?
Your Honor, he was picked up on the new charges, and I didn't know.
Okay.
I didn't know he was in jail, so I didn't have a chance to talk to him about it.
All right, have you had the opportunity to speak with him today?
No, I didn't, Your Honor, and I'm going to be requested to be appointed on his new case, so we
All right.
can wrap that up then.
So we can do a couple things. Let's assume for the purposes of this next part that he ends up entering a plea guilty to one or more of these violations. The court could then give him time served, but does he really want a sentence today, or do you want to wait to find out what happens on the other case? We don't care.
This is his first SOAR violation. The offer downstairs is for Killebrew to find the cost and this.
Okay, so theoretically, so we could also do this, Mr. Burdette. We can take a couple minutes and allow you some time to go into another room. Do you have a computer with you or something?
Yes, I do, Your Honor.
All right. So our next matter currently scheduled at 9:45, thus we have some time. And that is just a pre-trial and a show cause. So what we're going to do is we're going to take a recess here in place, allow you to use one of the other rooms, call into the Zoom. Do you have the Zoom number?
No, I don't, Your Honor.
All right. Mr. O'Brien, what we're going to do is make sure you have the opportunity here in a moment to speak with your counsel. Mr. Burdette's going to go into another room. He'll dial into the Zoom account, and then we will place the two of you into a private breakout room. And he'll come back and let us know when you're ready to go on the record if we're going to do so. You understand?
Yes, sir.
All right. Thank you very much. We are.
I don't understand. I mean, I do understand that, but.
All right, well, they rack up the next contestant, I guess. There is a new contestant in front of the board. Let's go back there.
Parole is signing in at Orleans Justice Center for revocation proceedings. Today is Thursday, February 5th, 2026, and it's 10:12 a.m. And our first case this morning is Mr. Green. Good morning, sir.
Good morning, ma'am.
Would you introduce yourself? Tell us your name and DOC number.
My name is Brandon Green, DOC number 493822.
All right, sir, thank you. And you have counsel with you this morning. Mr. Boucher, would you introduce yourself, please?
May it please the board, Kevin Boucher, bar number 03286, representing Mr. Brandon Green.
Thank you, sir. And we also have Mr. Green's sister, LaKaiser Green, and she wants to speak. And we'll ask for her remarks shortly. Your case this morning, Mr. Green, has been assigned to Mr. Tillis, so I'll turn it over to him.
Good morning, Mr. Green. How are you?
Good morning, sir. I'm all right. How about yourself?
All right, I'm going to read some violations and you can plead guilty, not guilty, or with a statement. Violation number 4, you failed to restrain from criminal activities. You were arrested on April 8, 2025, Orleans Parish Sheriff's Office. You were charged with possession of a firearm or weapon by a felon and possession of marijuana. The charges are of possession of marijuana less than 14 grams and possession of a firearm weapon by a felon were accepted by the district attorney's office. The charges are set for pretrial conference on 12/9/2025 and trial on 1/20/2026. The subject was found not guilty of possession of a firearm or weapon by a felon. The subject was scheduled for a bench trial on January 26, 26 for possession of marijuana, THC, and chemicals, subject by the schedule, under 14 grams and an unsafe vehicle violation. The trial has been reset for January 28, 2026. How do you plead? Guilty, not guilty, or with the statement?
Not guilty, sir.
Okay, Mr. Kevin, do you want to elaborate on that?
Certainly. Ms. Lakeisha Green, who's present on Zoom today, will testify, as she testified before the jury of 12 citizens, that she was responsible for placing the firearm in question, that Mr. Green had no knowledge of the firearm, no DNA was found in connection with the firearm to be tied to Mr. Green, and perhaps most importantly, ladies and gentlemen of the board, 12 citizens heard this case and found Mr. Green not guilty in 55 minutes.
Thank you, sir. Rule number 5. You failed to refrain from possessing a firearm as evident by your arrest on 4/8/2025, which you were charged with possession of a firearm or weapon by a felon. How do you plead, Mr. Green? Mr. Green, did you hear me?
Yes, sir. Not guilty, sir.
Not guilty with a statement?
With the permission of the board, we would incorporate the same statement we just delivered in connection with the previous violation allegation.
Thank you. That's what I thought. Rule number 10, violation number 10. You are in the arrear of $4,725 plus the $65 processing fee. No payment was ever paid as instructed. How do you plead?
I plead guilty, sir.
Okay. I guess at this time, we'd like to hear from your sister by Zoom. Ms. Green?
Good morning.
Lakeisha, tell the board exactly what you told the jury 2 weeks ago.
Okay. The weapon was actually placed in a car by me. It was actually an ex-boyfriend weapon. I was actually returning it to him. I was on my way to go get my hair fixed. I was actually returning it to him. Went to the residence where he was living at. The house was abandoned. He no longer lived there. So I still had possession of the weapon when I went to Brandon's girlfriend's house to get my hair fixed. He actually came in and asked me to use the car. Put in mind, this is my mother's vehicle. We all use the car. He asked me to use the vehicle. Me being distracted, like I said, when I actually got to the house, I actually shoved the gun on the side of the seat, like pushed it all the way under because my mother doesn't have tinted windows. And because the car was parked on the street, I didn't want nobody to see the weapon and break into the car trying to get the weapon. So I shoved it like on the side of the driver's seat, like pushed my hand all the way down and pushed it down. Brandon actually came in around 2, little after 2, and asked to use the car to go get something to eat. I actually gave him the keys, slipped my mind playing in my phone, forgot the gun was actually in the car. I didn't find out that Brandon went to jail until my mama called me. So the gun was actually placed. He had no knowledge. Nobody would have never known that the gun was in there just by getting in the car. You would actually have to search the car in order to, the way I had it shoved, you would actually have to search the car in order to know that a gun was in there. It wasn't visible, so he would have never known or had no idea that it was in there.
Ms. Lakeisha, is that what you told the jury under oath before Judge Pittman on the 21st of January?
Yes, sir.
And is what you're telling this board, as you told that jury, the truth, the whole truth, and nothing but the truth?
Yes, sir.
Listen to the board. They're going to have some questions for you.
Okay.
Any of the members have any questions for her?
Oh, I don't have any questions of Miss Green.
Okay, thank you, Ms. Green.
Thank you.
Does she have permission to sign off, ladies and gentlemen of the board? Because she wants to go to work at Dollar General.
Sure.
Yes. Thank you.
Thank you. Thank you, Ms. Green.
Mr. Green, what about the drugs that you had? Are you on drugs? You're using drugs?
Sir, the drugs was actually, I didn't have a lot, but I spoke with my parole officer, Miss Virginia, and she recommended me to get the dispensary card for marijuana, which is on my file. Everything should be in my file for marijuana, but any other drugs, no, sir.
The marijuana in question, ladies and gentlemen of the board, was found inside of a registration form. Ms. Green has indicated the fact that multiple people used the vehicle. It was approximately maybe 1 inch worth of a partial cigarette. It was not a large quantity of marijuana, and that matter is presently set for trial.
Board members have any questions?
I didn't understand what you said about the card. Mr. Green.
Ma'am, you speaking to me?
But yeah, would you tell us again what you said you were advised by your parole officer about the card?
No, not about the car. This maybe before the car incident. Miss Virginia, who was my parole officer before Miss Tiffany Jones, she had told me that I was dealing with a herniated disc in my back, and she was like, "Well, you can get a medical card for marijuana, and you know, if you want to use marijuana, you can use marijuana, but you got to get a medical card." So I went and got a medical card for the marijuana, but the marijuana that was in the vehicle, I didn't have any knowledge that the marijuana was in that vehicle at all. That marijuana didn't belong to me at all, man.
Okay. Well, let me just advise you that the use of prescription marijuana has to be approved by the board,
That's important.
not by the officer, just FYI.
That's important.
Okay.
Yeah. Okay. That's all.
Later. You're gonna have to convince me about the gun, because the state trooper says the gun was in plain view, that he could see the extended clip and all of the extended clip portion of the gun, which was a 20 shot extended clip, above the driver's seat. Explain to me how that reconciles with what your sister just said.
if I may, Mr. Board Member, sir, I'm trying to read your name, sir, correctly. I want to pronounce it. Prater, Mr. Prater, thank you, sir. The bottom line is that there was no physical photographs showing that aspect of the weapon. More importantly, I asked specifically about whether or not that gun was tested at all. But they ran a test for DNA on him, but nobody bothered to tie anything at all with respect to the firearm. The clip, there's no photograph of that clip being shown as being visible. That's what I'm trying to drive at, sir. And the evidence that was produced at trial, and again, it wasn't like the jury deliberated very long on this. I just think that needs to be considered.
Consider it.
Any other questions?
I know. I'm ready to vote.
Ready to vote, Mr. Tillman?
Today, my vote's going to be in violation number 4, possession of marijuana. And my vote will be to revoke your parole.
Mr. Prater?
I concur, and I think the gun, it's a he said, she said thing, and I believe that the state trooper saw it. The fact that the DNA, that's irrelevant since it wasn't tested. Revoke it.
All right, and I do agree, Mr. Green. My vote also today is to revoke for the violation of condition number 4. Today, sir, your parole's being revoked. Good luck to you, sir.
Denied.
So Lindsay puts in the chat, if everyone is sharing this car, maybe don't leave the guns and the drugs in there. Yeah, but where's the fun in that, Lindsay? I mean, you know, if you're going to have guns and you're going to have drugs, you ought to just leave them out for everybody. I'm just saying. You know, maybe it's just me. Anywho, let's go back to Judge Elmore, because the contestant that we saw earlier is back, it looks like.
Court recessed in place. Are present again. Mr. Burdett, how would the defense like to handle this today? Either set it aside, do a plea, it doesn't matter, just one.
My client's gonna be entering a plea today.
Okay.
Pursuant to the agreement, it's just gonna be fines and costs. And then I'll make myself available this afternoon to zoom in down in district court to resolve that.
Thank you. Mr. Carnes, does that sound accurate to what you understood we're doing?
Yes, sir.
All right. Mr. O'Brien, I'm now going to turn to you. Can you still see and hear me?
Yes, sir.
Thank you. Please raise your right hand. You swear or affirm that the information and testimony you're about to provide to this court will be the truth, whole truth, and nothing but the truth, sir?
Yes.
You may lower your hand. All right, Mr. O'Brien, I'm going to go over this again with you as it's been a few months. You are currently charged on a piece of paper that's called a request and summons for a probation violation. On that, you are alleged to have violated your probation terms and conditions in 2 ways. Count 1 alleges that you violated special condition 4.22. That condition requires you to comply with the instructions of your field agent. And more specifically, it's alleged that on September 30th of 2025, you had failed to comply with a written order from your field agent to verify your registration underneath the Michigan Sex Offender Registration Act. That is what's called a technical violation, and I'll explain to you what that means in just a moment. Count 2 alleges that you violated condition 1. That condition of your probation requires that you are not to violate any criminal law of any unit of government. And again, it's more specifically alleged that on or about September 30th of 2025, you had violated Michigan law by failing to register with local law enforcement as required under the Michigan Sex Offender Registration Act. And that one is called a non-technical violation. When there are technical violations, such as count 1, the court is required to, is limited to any sentence or additional punishment to a sliding scale. For 1 count, it's one technical, it's up to 15 days. For 2 technicals, it's up to 30 days. For 3 technicals, it's up to 45 days. For 4 or more, the court would no longer be limited to that sliding scale and would only be limited by the amount under the law. Similarly, for a non-technical, such as count 2, the court is not limited to a sliding scale and is only limited to the amount allowed under the law. So far, do you understand?
Yes, sir.
In this file, you originally were convicted of assault, resist, obstruct a police officer. That is a felony punishable by up to 2 years and or up to $2,000. Therefore, it's a felony. Therefore, that sliding scale is the one I mentioned. Now, there's also another interesting quirk here is when a single act is alleged and could support 2 probation violations, the court would treat them as one because they are what's called the same transaction of events. In this instance, while it's listed as 2 counts, I'm required to treat them as 1 count. And it's a bit silly because no matter what, they're treated as non-technical, which means the sliding scale that I mentioned earlier would not apply. Now, if you plead guilty to these actions, allegations, you will not have a hearing or a contested hearing today, and the prosecutor, you would be waiving the right to have the prosecutor prove the allegations by a preponderance of the evidence, the right to question, cross-examine the evidence against you or witnesses against you, as well as the right to present witnesses, evidence, or testimony if you chose to do so. And of course, you'd be waiving the right to remain silent and not have that silence used against you. Do you understand that, Mr. O'Brien?
Yes, I do.
Now, there's another factor I want to make sure I cover, and I have no reason to think that there's any deception being played here by the prosecutor between he and Mr. Burdett and you. But if you make an admission here in a couple minutes, that could be used against you in the other case, which I'm told you're going to appear for an arraignment today. Any admission right now could be used against you in the other one, so therefore you'd be found guilty, if that makes sense. But I'm told today that you, through Mr. Burdett, with the prosecutor, have reached an agreement that will resolve that case today as well. And as I understand it, the sentence agreement would be that you would only receive fines and costs. Is that what you understood?
Yes, sir.
Knowing all that, do you still wish to enter this plea here today that we've already talked about?
Yes.
Again, actually, I didn't say it, but I understand you're going to plead guilty to these 2 counts. Now, there's also some discussion here between the counsel.
Two days then. 2 days. This will be the second day.
Okay. Yep, all right, good, thank you. Mr. Stapleton, is that what you understand is going to go on and you're going to make that kind of recommendation?
Yes, sir.
All right. Have there been any other probation violations involving Mr. O'Brien in these 2 files?
No, Your Honor.
Oh, Mr. O'Brien, it was my failure. I forgot to make the note here. And I told you what the conviction was in file 13990, but I forgot to tell you what it was in 13991. 1 second here. Oh, well, this is a little more interesting. In the other file, 13991, you were convicted of a misdemeanor of larceny with the value of at least $200, but less than $1,000. Now, because that's a misdemeanor, and this is why I said it's a bit more interesting, in that file, when there's a misdemeanor, the court's limited to a sliding scale of 5 days, 10 days, or 15 days for your first, second, or third technical violation. But because there is a non-technical, it wouldn't be limited to that sliding scale. But it's my understanding that in both of these files, there's an agreement between you, through Mr. Burdett, and the prosecutor that there wouldn't be an additional jail. Is that what you understood?
Yes, sir.
Is that how you wish to resolve these two probation violations?
Pleading guilty.
All right, thank you. So, even though you said that's what you're going to do, I have to actually ask you. So here we go. As to the two counts of probation violations that appear in both of these two files, how do you plead, sir?
Guilty.
All right, thank you. One moment. To the file. The court takes judicial notice of the terms and conditions of probation that appear inside each of the court files. They were signed by me on June 9th of 2025 and subsequently acknowledged by the defendant. They were both dated the same date. All right. Mr. O'Brien, is it true that you had to register as a sex offender either through these cases or through some other case?
Yes.
And is it true that your probation officer told you that you needed to go get this done?
Yes.
And is it true that you failed to get it done in a time frame he told you to get it done, which means you didn't report to local law enforcement, such as the Michigan State Police Post here in Wexford County?
Yes.
Mr. Carnes, do you believe you provided a factual basis?
Yes, Your Honor.
Are you aware of any other promises, threats, inducements?
No, Your Honor.
Do you believe that thus far I'm in compliance with the court rules?
Yes, Your Honor.
Mr. Burdett, do you agree with all three?
Yes, sir.
Thank you. Are we able to proceed to sentencing, Mr. Carnes?
Yes, Your Honor.
Mr. Stuppelman?
Yes, sir.
Mr. Burdett?
Yes, sir.
All right, I need to, before we turn to sentencing, Mr. O'Brien, I need to advise you that you have the right to be physically present in the courtroom when I give a sentence. That's how it works in every case. However, if you're willing to, you can waive that right and allow me to conduct sentencing right now. Do you waive that right to be physically present and therefore allow me to use the video technology?
I do waive that right.
Mr. Burdett, any objection?
No, sir.
I find pursuant to the Michigan court rules that it's appropriate to use the technology, and I turn now to Mr. Stempleton. Sir, your recommendation?
Thank you, Your Honor. The defendant was originally sentenced June 9th, 2025. Two dockets. The original sentencing guidelines were 17 months. He's done well and is actually in compliance now. He's I've not had any problems with the defendant at all. I recommend the defendant be sentenced to 136 days jail with credit for 136 days and probation be continued and fines and costs preserved.
Mr. Carnes?
Thank you, Your Honor. This does appear to be the defendant's first SORA violation. I do take that seriously, but I also understand sometimes. Oh, I hope this is it, because obviously it gets. I will push harder on future violations, but it is good to hear that Mr. O'Brien is doing well on probation. I think it's a reasonable resolution today, so I'd ask the court to go along with it and impose time. So thank you.
Mr. Burdett?
Yes, Your Honor, I agree with the prosecutor. My client has fully registered with SORA. He's done well on probation. So we're just requesting you file the recommendation this time.
Mr. O'Brien, is there anything you wish to say before I issue the sentence on these violations today, sir?
No.
All right, thank you. All right, well, I trust today the advice and comments from Mr. Stempleton. He normally is very open about probation performance by probationers underneath his supervision. And I accept that here today. I can say that other than this, I haven't seen Mr. O'Brien for the court. And again, sometimes I understand that it's interesting in the state of Michigan. There are differences of opinions, even within the Court of Appeals, Supreme Court, about whether or not SORA is a punishment or not a punishment. But I think it definitely has that impact, and it requires a person to go out and register. And sometimes doing that can be difficult, but he's overcome that through the guidance of the council and the probation department, and he's now therefore in compliance. And there hasn't been any other violation, which is really quite important here, as I don't have an allegation of a new crime here before the court. So therefore, the court will accept the recommendations from the probation department. I think technically what I have to do is, one, preserve fines and costs, two, continue probation as previously set by this court, and three, I think I have to give 137 days with 137 days of credit to count yesterday and today. So therefore, that's the sentence of the court. All right. Mr. O'Brien, the next thing that's going to happen is in each one of these files, you're going to get 2 copies of a document. Now, you've already had this document before, but I have to give them to you again. You have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal, which only happens when someone's been convicted by a trial or at a trial by a judge or a jury. Because of the pleas in this case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want me to approve the appointment of an attorney, you may complete the bottom half of one of these documents and return it for each file and return to the court within 42 days. Now, again, I told you that you're getting 2 copies in each file. The first one, you're actually just going to put your initials on. Doing so neither elects nor waives any rights. It merely acknowledges receipt of the other copy. The other copy is for you to take and then return to me if you want me to appoint an appellate attorney, or it's for you to either put into a recycle bin or trash or burn or in an appropriate receptacle. But I don't need it back if you don't want an attorney. Okay?
All right.
You have any questions, Mr. O'Brien, about what we have done today?
Not at the moment, sir.
All right, good. Well, right now is the last moment I'm going to see you. So, all right, well, I'm done with you. Anything further, Mr. Burdett?
No, Your Honor. Nate, I'll see you this afternoon.
All right.
Okay, thank you.
Is he on, so he's been arrested for the other charge, right?
Yes, Your Honor. He's going to be arraigned today. I'm going to see if I can appear by Zoom at 1:30.
Okay.
Get an appearance, and then we can wrap it up today.
All right, no problem. Anything else, Mr. Carson?
No, Your Honor. Thank you.
Anything else, Mr. Stuppleman?
No, Your Honor, thank you.
All right, folks, thank you very much. We are adjourned.
For those of you expressing concern about the keyboard in Judge Elmore's court, I would like to point out that that keyboard is quieter than it used to be. Still really loud, but it used to be a lot worse. So that wraps up for today, my friends. We will be back live tonight on this channel for Sidebar, 8 p.m. Eastern, 5 Pacific. I won't be here, though. Michael Groff will be leading the panel, so please do tune in and give him and the rest of the panelists your support. Really appreciate that. But I will be back here tomorrow morning, the normal time, 9 a.m. Eastern, 6 Pacific, a half an hour early for channel members. So I personally look forward to seeing you again then. And if you haven't had the chance, please do go check out In the Blind with Mike and Dan. It's our new show. It's on its own channel. I'm sure Barbara will throw a link in there real quick for me right now, just so you've got it. A lot of fun. We did another live show last night, so if you weren't able to catch it, please do go check that out. And while you're there, sub if you haven't already, hit the like button, leave a comment, stuff like that. We really need everybody's help to get that show found and get it to grow. And those interactions tell the algorithm that we're worth showing to others. So please do that for us. But again, I'll see you tomorrow. In the meantime, go have yourselves a great Thursday. And the rest of the team will see you tonight, hopefully. Take care. God bless.